Well, good evening. Oh, we can do better than that. Good evening. Hey, let's be happy tonight. Thank you all for coming out tonight. My name is Steve Daugherty, and I am the founding attorney for a law firm here in town called Montana Elder Law, though we do serve the entire state. And a little bit about me and who I am and why I might have something to offer to you. I started my law career here in Missoula several years ago, and I was just doing general estate planning. So I was doing wills and trusts and powers of attorney, and it just due to the clientele I kept getting, and people, birds of a feather flock together, people kept sending me their friends, and I kind of turned into more of an asset protection lawyer because a lot of my clients were small business owners, a lot of people in the construction industry, people who were at risk of getting sued. And so by the nature of my clients, I began doing a lot of different estate plans that had some asset protection components to it in the event they get sued at work. So if the contractor has a bad day at the job site, that we would try to make sure that lawsuit was limited to the job site or the construction company, that it wouldn't bleed over into the kids' college savings, right? And we all have, every law that we have is based on some kind of public policy, okay? And so the public policy is if every future entrepreneur is afraid of getting sued, then there's going to be fewer businesses started. And so you can't protect against fraud or anything like that, or negligence, but mistakes happen. And so we have strategies that implement, whether that's a limited liability company, an LLC, or trusts, or family partnerships, or a number of other strategies that we can utilize to try, as well as implement the use of insurance, to try to stave off the trial lawyers, right, so we can separate our professional liabilities from our personal assets. Do we have any lawyers here tonight? None we got only one that's willing to admit it. All right. No offense, but I want to pick on the trial lawyers because my job is to keep my clients and their family as well as myself away from the courthouse. Okay? And so I did that for a number of years. And it was in 2015, I got a call that ended up completely changing the trajectory of my career. And it was a lady up in the Rattlesnake, and she called and she said, and I don't know what she had heard about me or my practice, but she said, "Steve," I'll never forget, "Steve, I'm not a multimillionaire." That was the first thing she said. "But my husband and I, we're retired, our home is paid for, and we're comfortable." But she said, "I'm afraid if he gets sick, then I'm going to have to sell the house to pay for his long-term care." I came to find out that's exactly what happened to her sister in Idaho, is that her brother-in-law, her sister's husband, had a severe stroke, had to go into long-term care, and had to sell the house. As a matter of fact, she said, "Is there a way to protect my house so that if he gets sick, I won't have to sell it and move in with the kids?" And I remember trying to figure out what scared her more, having to sell the house or move in with the kids. Either scenario is a crisis we would like to avert, right? And I said, well, yes, there's a way that you can do it, but it's got to be done perfectly right, or it will be worse than doing nothing at all. And that kind of applies to a lot of legal and strategic planning, that you can forfeit some of your statutory protections if your legal work's not done correctly. And so I explained to her how we could protect her home from nursing home costs. God forbid either she or her husband ever become ill. And the next week, I got a call from their neighbor. They said, "Hey, can you do for us what you did for so-and-so?" And I said, "I'd be glad to." And I helped that couple. And within a few days, I got a call from that couple's cousin. And the word spread, and within 6 months, I had a client in Plentywood. You guys know where Plentywood is. You understand? And that's when it dawned on me, you know what, there's just not a lot of elder law attorneys in Montana. Now, if you go down to Orlando or Scottsdale, you can't throw a rock without hitting an elder law attorney. But in Montana, we just didn't have a lot of specialty practitioners, okay? And I had never really thought about it when I was in law school. But when I started doing these first few estate plans, and tonight I'm going to explain exactly how I help those people so that you can utilize those same protections for yourself if that need ever becomes a reality. But it took me back to when I was just a kid. My dad's mother, my paternal grandmother, she was a farmer, a widowed farmer. She lost her husband when she was in her 30s, never remarried, raised a bunch of boys, a bunch of animals on about a section of land. And, she's an old school farming lady. She was very tough. And she had a string of poor health along the way, a lot of serious issues, including cancer. But being a tough farming lady, she just kept beating everything that came her way, kept shocking the doctors, right? Well, the one thing she couldn't beat, it was at a relatively early age, at age 65, my grandmother was diagnosed with Alzheimer's disease. And, I remember this as a kid where my family, my uncle, a couple of my uncles, we all took turns trying to care for my grandmother. And if any of you have ever had a family member with severe dementia, you know it just becomes a matter of time before it becomes a disservice to everyone, including the sick loved one, when you try to doing it yourself, because we're not professionally trained, nor can we provide that care 24/7, right? Just because someone doesn't get up at 2 a.m. and walk out the front door doesn't mean that you're not sleeping on eggshells, right? And so it was just a matter of time before we had to do the only thing that was optional, and that was to find her a senior home that was high quality and took great care of her and so forth. Well, when she went into the long-term care facility, the family, we never really thought she would thrive, so to speak, because she had lived in that house for 40-something years. She had all those pre-existing conditions. We just weren't very optimistic for her longevity at that point. Well, my grandmother kept surprising everybody, and she kept going and going and going. And when it comes to dementia, your heart and your lungs and everything else can be relatively healthy, right? And being a farmer, she was like a lot of farmers and ranchers. She was land rich and cash poor, as they say, right? And so it didn't take long to deplete her savings. And then I remember, as my father and my uncles, they started writing checks to the nursing home for her care. Again, never thinking she would be there very, very many years. Well, after a while, they realized that they were going to be forced to pay for her care with the only available asset that she had, which was the farmland. So they began selling off property every year or so, 40 acres to this neighbor and 80 acres to that neighbor and so forth. And I remember the process. It wasn't so much that the family's inheritance was disappearing. It had nothing to do with that. It was that all of that hard work for a lifetime, through no fault of her own, was disappearing. And if any of you have ever had land that you've owned for a while, family land, and you sold it, you're introduced to something called capital gains taxes. And we'll get into it a little bit, but what was happening is every time they'd sell off a piece of land, they were getting crushed with the capital gains taxes, so they'd always end up with less than they thought they were going to have, and so they'd have to sell some more land. And it was just a kind of a downward spiral where the taxes and the nursing home costs began to cannibalize all of the assets. Well, that farm, which was just over 600 acres, when she passed away almost 10 years to the day after going into the nursing home, was a house in 20 acres. I remember it very well. And that's what kind of struck me when I started helping these people locally do that. And I changed my career. I still have a lot of the high net worth clients that I used to serve, and happy to continue to help them. But I pivoted my law firm. I said, this is what I want to do. Because I realized if I had a time machine, and if I could go back to 1985, I could literally save the family farm. Well, I don't have a time machine, and I can't help my family, but I can help yours. And so that's what I do now. And I changed the name of my law firm from the Daugherty Law Office to Montana Elder Law. And there's 4 attorneys, 4.5 attorneys that we all do this, and a large staff, and we serve the entire state now, okay? Because there's just not a lot of people that do this kind of work. And so our mission statement is to utilize every applicable law opportunity to protect the assets, peace of mind, and the dignity of aging for Montanans. And when I'm talking about that, when I say dignity of aging, it means a lot of things, but it also means that we don't suffer what my grandmother suffered in seeing everything that she ever had disappear through no fault of her own. And particularly with, it's hard for both men and women, but I see it even harder for most men, particularly if they were the breadwinner, for no fault of their own, just losing everything. And that can really hit a family really hard. So I have the greatest job in Montana is that I prevent that for a lot of families. Now, let me ask you this. What is the single greatest financial threat facing Americans? Now, when I say financial threat, I don't mean getting scammed for $5,000. I mean being broke, where you have $0 in the bank. What's your single, just curious, I told you that I help people protect against lawsuits for many years, so there's a lot of ways that you could go broke in this country. But what is your single greatest financial threat? Anyone? Healthcare cost. 60% of the people who filed bankruptcy last year cited medical expenses as the major contributing factor. But if you dig down into the statistics a little bit, you realize how many of this is actually long-term care. What we're going to do tonight is I'm going to give you a basic introduction to estate planning, and then we're going to talk a little bit about long-term care and how you pay for it. And then we're going to combine all of that, and I'm going to try to teach you how to use the estate planning laws so you can pay for long-term care in a way that most of you have no idea that you can. That's the purpose of the workshop. I teach these all over the state now, and very, very few people are aware of these laws, including attorneys. That's the reason I always want to know if there's some attorneys in the office so we can work together if that ever becomes a possibility. What are the goals of estate planning? When you think of an estate plan, we tend to think of rolling hills and galloping horses with an estate. What's an estate? Well, we all have an estate. Now, if all you have is a closet full of t-shirts, you have an estate. It's just very modest. And you also have an estate plan. Now, if you say, hey, Steve, I don't have a will or anything, I don't have an estate plan, I'm here to inform you that yes, you do. And it was created by the state of Montana. For all of those who pass away, what we call passing away intestate, which means you have no will or trust in place, then we have to have, the state has a formula for dividing your assets, and it's trying to mimic next of kin, but it may not be the plan you need. For instance, let's just say that you have a child or grandchild or whatever that's on state benefits, special needs or disabled or what have you. If they inherit $50,000, they instantly lose all of their state benefits, which over their lifetime will be a heck of a lot more than $50,000. So there's a number of reasons that you may not want to use the state's plan for you. So we all have an estate, we all have an estate plan. What I want you to do is take control of your estate and your estate plan. So how do we do that? Well, a lot of us think that an estate plan has to do, all right, when I kick the bucket, what happens to my stuff? Well, actually, we need to have documents while we're alive. And the younger we are, the more important that is. So we want to protect the assets while you're alive, and then when we pass away, we want to pass those assets to whom we want in the way that we want, right? We don't want a child or grandchild getting way too much money at age 18. Or make up your own scenarios that apply to your family. You want people to, perhaps you don't want the kids to sell the family cabin for a period of time, right? Keep it in the family, maybe for another generation. There's a number of ways that we can use an estate plan, not only to pass on your assets, but your values. And then we just want to make sure that when that day does come, that we have, quote unquote, our ducks in a row, where it's not going to cost a lot of money to administer. And it's not necessarily the money, folks. It's not the dollars. It's the time. If someone's stuck in 2 years of probate, it's delaying emotional closure. We don't want to unload that on our loved ones. And we want to avoid any taxes if at all possible, right? So that's our goals. Now, what are the 6 basic documents of an estate plan? This is the basic documents. We all need, in Montana, we need to all have these. Even if you find some online forms, at least have that in place. Let's start with the documents you need while you're alive. We call these your incapacity documents. So if I'm in a car wreck and I'm in the emergency room, I can't make decisions for myself. Or if I have aged and developed dementia or whatever the scenario might be, maybe I don't have the ability to speak, to voice, my wishes or whatever the scenario is. Remember when we were talking about I want to keep my clients' families and me out of the courthouse. Well, if you become incapacitated and you don't have a durable power of attorney in place or a healthcare power of attorney in place, in Montana you need both, then your family's going to have to hire a lawyer, go to the courthouse, get in front of a judge, and get appointed your guardian and conservator. And let's just assume it's not contested and goes as smooth as can be. It's still probably going to run the family $2,000 or $3,000, and it's going to take 2 or 3 months. Now they'll issue what's called an emergency temporary appointment, but for this to formally happen, call it 2-3 months, $2,000 or $3,000. Now I tell people, whenever you go to the courthouse to get something done, add a 0 to what it would cost to do things privately. And here's an excellent point. If you hired a lawyer to create some basic powers of attorney, they'll probably charge you $200 or $300. If you don't do it, $2,000 or $3,000. So add a 0. It's hauntingly similar with so many other things. So we want to do things privately the best we can. Not only, and again, it's not just the money, it's the time involved, right? So durable power of attorney, that allows you to appoint someone to sign paperwork on your behalf if you can't do that yourself. For a married couple, we go ahead and appoint each other immediately so they have that power. Now, are the 2 of you married? All right, thank you for volunteering. So let's say he's gone fishing, hunting, or whatever, and he forgot to sign the taxes, and his tax statement is April 15th. Well, you can run down to the accountant's office and sign that on his behalf as power of attorney. But we don't necessarily want to give the kids power of attorney today, right? You don't want to come home and see a sold sign in your yard. So for the kids, we call that a springing power of attorney. And what that means is if he is injured and she can't serve, maybe she's injured too, or maybe she's already gone to a better place, if and only at that time, the kid's power would spring into effect at that time. So whenever we're doing powers of attorney, if you're single, you may not want to appoint someone immediately, but maybe you just want to put some kids. And we always want to have more than one, right? We want to have some backups just in case. And so when I'm working with a married couple, we make it both immediate, and then we're going to enlist 1 or 2 of the kids, or you can name all the kids jointly to keep them happy. But you got to have both of those. If you have both of those, there will not be a guardianship or conservatorship hearing. And here's another issue for blended families. We're going to talk a little bit about blended families tonight because it's underappreciated in the legal community. And when I mean a blended family, I mean there's at least one child from a previous relationship, okay? Or it could be like the Brady Bunch, right? And so with a blended family, this right here can be contested, where the 38-year-old daughter thinks she should be the one making decisions, not wife number 2 that's only been married for 6 months, right? And if that's contested, then it goes from being a $2,000, $3,000 conservator guardianship to a $50,000 plus. So let's not I don't want a judge to ever make any decisions about my life or my assets. And so that's the same thing. I want you to take control and say, hey, hopefully I'll never need this, but if I do, I want this person to be, making these decisions. And it might make sense in that blended family for the daughter who's a CPA to handle the money, but spouse number 2 to answer the healthcare question. So you didn't have to be, they don't have to be identical. You want it to suit your wishes, your needs. So if you're not able to express that on your own, we've already got it in paper. All right. Likewise, we all need a living will. I hope none of you ever need this document, but this is the document. This is not a do not resuscitate. The living will, also known as an advanced directive, thank you, is a directive in advance, and it says, hey, future physician, if you diagnose me as being in a permanent, irreversible, vegetative state, my doctor clients tell me that means that there's no brain activity, I'm on a respirator. But this living will says, future doctor, if I'm ever diagnosed as being in that condition, I don't want to be kept alive artificially. Does 2 things. First of all, it honors my wishes. Second of all, it doesn't dump a really, really horrible decision on my family to make. Some of you may remember from the 90s a case down in Florida, the Terry Schiavo case. And that was a case where this lady, relatively young, I think she was early 30s, was in a coma, and her husband knew that she wouldn't want to stay, because she was in a coma for a long time. Her parents wanted to keep her alive, praying for modern medicine to come up with a cure or whatever. It went all the way to the state Supreme Court. So we don't want our private affairs in the court docket, right? So better to have it and not need it with a living will. If nothing else, do your family a favor. When I'm doing this, I do a HIPAA authorization. We've all heard of HIPAA laws, and doctors are afraid of getting sued, right? So they don't want to do anything, particularly if one part of the family wants one thing done and the other part of the family wants something else. They want to have all these documents in place so they don't get sued. But, HIPAA, that's Health Insurance Portability and Accountability Act, I believe. But basically, the doctors can't share your medical records with your kids. They're not supposed to share it even with your spouse. They typically do, but they're not supposed to. Or maybe they'll just in a limited amount. So what I always do for my clients is when we're doing this, I just go ahead and do a HIPAA authorization where you go ahead and authorize, all right, if I'm ever out of it, these are the people that you may release my medical records. So it's usually spouse and kids, the immediate family, or whomever is appropriate, right? You may not have a spouse, you may not have kids. Whoever is appropriate in your situation, you can go ahead and authorize that. And of course, when we're doing this, we want to keep all these documents together so we don't miss them if they're ever needed. So these are your incapacity documents. Now, then we need to have what's called testamentary documents. Think last will and testament. So this means that we are not alive. What are what documents do we need then? Well, you need either a will or a trust, and we're going to break that down a little bit. When you're creating an estate plan, you got 2 options. You can have a will-based estate plan, or you can have a trust-based estate plan. Pros and cons to each. Now, if you have a trust, you're probably going to have a will too. It's kind of a companion document. The trust is the controlling document. We'll explain the difference here shortly. But you need one of these documents, and all a trust is, folks, when you're in law school, they teach you, a trust is a will substitute. And that's what it's designed to do. Okay? It's governed by contract law, not probate law, so it's administered privately, and it gives you a lot more flexibility than a will. But you may not need a trust. Either way, they all kind of have the same components. If I die, or not if, when I die, most likely, this is who I want in charge of all of my affairs, and these are the people who are going to get my stuff, and this is how they're going to get it. So if you got a will, you got a trust, that's what it's going to say. It's just maybe getting to that outcome is a little different. Personal property memorandum. This is the simplest document you'll ever have, but it might be the most important in terms of maintaining family accord and avoiding future estate planning costs for yourself. I never like it when I have a client or a new client comes in, they say, "Hey Steve, here's my existing will. Tell me what you think." And I start flipping over there, and I get over there to page 3 or 4, and I start seeing canoe to Sarah, earrings to Louise, the 38 I keep in my purse to Johnny. Why do I not? So what I'm talking about are personal property items. So there's 2 types of properties. Real property, which is the land you own and anything attached to it, real estate, and everything else is personal property. Okay, your car is personal property. And when I start seeing all this big lengthy list of personal property in the will, what I'm thinking is either they did it themselves, an attorney who does not do estate planning very often did this, or in a more sinister role, maybe there's an attorney that did this to create future work for themselves. Folks, it's not the land or the bank accounts that the kids fight over typically. It's the grandfather clock. Some of you can kind of relate to some of these stories. Well, Dad promised that I could get the 4-wheeler. And you know, when you lose a loved one, every little molehill can become a mountain, right? We're not sleeping well, we're emotional, we're stressed. You're dealing with your twin sister that you've been fighting with since you came out of the womb anyway. So what we want to do is we want to eliminate those. And every state in the Union has a statute that authorizes what's called a personal property memorandum. It looks like this. Don't worry about the words. I know it's hard to read. What I want you to notice is there's 2 columns of blank empty lines. Okay? Whenever I'm doing an estate plan, I think I lost the power of my clicker. All right, we're back up. I want all of these documents in a 3-ring binder. When I'm doing an estate plan, we don't lose. Listen, I've administered hundreds of estates, including both of my own parents. And I know what it's like to wonder, have we found everything? I also know what it's like when you can't find the living will and you need it desperately. Okay? So when you have your estate plan, I don't want it in a bunch of loose envelopes. We don't know if we got all the envelopes. Put it in a 3-ring binder. That when we go to time to administer it, whether you're incapacitated or you've been struck by lightning, everything that we need is in this book. You just tell the family, hey, top shelf of the bookcase is my estate binder. If anything ever happens to me, just grab that. Everything you're going to need is in there. Well, the personal property memorandum, let me back up. Sorry. Well, just bear with me. I don't know why I'm having some technical difficulties, but I want to go back. The personal property memorandum, you remember there was pages with 2 columns? The first column says, description of the personal property. My car, all my jewelry, my diamond earrings, my wedding ring, whatever it is, you write on that line. See, this is something that you fill out in your home with a pen in hand. You don't tell your lawyer that you want your earrings to go to here. You just have that personal property memorandum and you handwrite in there, earrings, and you go over there and you put to Louise, right? And when Louise doesn't call you on your birthday, you get out your pen and you scratch through her name and you write Mary. Well, guess what you just did? You updated your estate plan without having to call me and me charge you $100 to do that, right? So the personal property memorandum, that's really, you don't do it when we're signing all of our documents, you take it home, something pops in your head, you write it. Maybe a kid says something, all right, write it. Maybe you acquire something in 2 years from now and you put it on there. Or maybe you sell something, you scratch it out. But it's kind of a working inventory that allows you to control that without having to hire me. See, the thing is if you think I'm going to ding you for $100, you're probably not going to make the change. You say, oh, the heck with it. I'll deal with her another way, right? And then the last document on there, on that page that I apparently can't go backwards and see, it says a letter to heirs. Folks, this might be your most important estate planning document. And it's not one that I create. It's one that you write. It could be as sterile as a checklist, such as call these 8 people. I have no life insurance. The gold's buried under the doghouse. These are the things that we pull our hair out when it comes time to administer, things that only the decedent can answer. Okay? And so if you can just give us a little to-do list, right? My neighbor owes me $5,000. Make sure you collect it, right? Or whatever. It allows us to administer these things. Folks, I said that about life insurance. I mean, how long do you look for something before you decide it doesn't exist? Depends on how stubborn you are, right? 1.6 billion with a B, $1.6 billion of life insurance proceeds go unpaid in America every year because the families did not know there was a life insurance policy. But equally important is letting the kids know that there is a life insurance policy, is letting them know that there is not one. You know, how do you know whether or not mom had one of those little $50,000 things that you get from the bank? You know, you're always getting those letters. How about here's some term life? How do you know, right? That's the other reason we want the binder is if you do have a life insurance policy, I don't need the whole policy in there. Get a copy of the front page, or if you get a statement. As a matter of fact, if you take all of your bank statements, financial statements, if you're getting it in the mail, next month, rip off that first page. I don't need them all, just the front page, because that's going to tell us the name of the institution. It's going to give us the contact information. If it's a life insurance policy, it'll tell us how much. Or if it's a bank, you know, it'll tell us. So all you got to do is you get those statements, and if you get them electronically, just print them out if you can, or figure out a way, or just handwrite them on a piece of paper. Get them in there, and then okay, boom, 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 boom. Now we can administer this stuff very quickly versus hiring a private detective. So, letter to heirs, huge, huge document. But you know what, folks? Maybe you want to say a little bit more than you don't have life insurance, right? See, I never met either one of my grandfathers. They both passed away before I was born. But I'd give anything if we had like a handwritten letter, laminated, that said, this is what I believed in, this is what I stood for, this is what I valued, this is what I learned. Right? Because I would recognize some of those characteristics and I could relate. And that would allow my grandfather to pass on to me his values, right? I never saw any of their assets. But you can preserve your legacy of your values, and maybe you tell a little story about your family. You know, our kids fail to realize that there was a life that existed before they were born. And so, you know, maybe it's a time that you can say whatever you want to. Maybe there's some things that need to be said that haven't been said. I love you. I don't love you. Whatever's appropriate for you, right? So, I have yet to see that inheritance yet. That's a good one. Or you are my child. Oh, that's funny. Exactly. Right? So letter to heirs is a powerful document, does two things. Number one, it makes the administration so much easier, folks. I had a client pass away. Well, she wasn't my client. I never knew her. But her daughters hired me. One lived in Minnesota, one lived in Pennsylvania. And their mom passed away. And when they told me the story, she lived in a big place down in the Bitterroot. But in her 80s, as her health declined, she moved into a senior residence here in town. And, I'm thinking, big place, little place, where'd everything go, right? I've done this long enough to kind of recognize these issues. And so I asked the girls, the girls, they were in their 50s. I asked the girls, I said, do you know if your mom had any storage units rented? And they said, no, I don't think so. Well, it didn't sit well with me because I asked them, I said, what, did your mom sell the stuff? She give you stuff, whatever? She said, no. They seemed very uninterested in the discussion. And so I had my paralegal, I just said, just call around some of the major ones just to see if there's a storage unit. Well, we found one out there. I can't think of the name of it, but it's right. It's out there by the old Walmart, right across the river. And we found one there, and there was actually three. They were all small. I'm guessing when she passed away, there wasn't any large ones. So she had three of these little 4x8 deals. One of them was full of nothing but boxes of photo albums. That might be priceless, right? These girls, and what would have happened after not paying that bill for 2 months? It'd have gone into the dumpster, right? And so if you got, I've had people pass away and they have a storage unit up in Polson with some jet skis in it. And it is, so those are the things that don't fit nicely in a will, right? And so if you write a letter, it's tremendously helpful. Tremendously helpful, right? Whatever it might be. You're not my child. Whatever is appropriate for your family. All right. And then what are you going to do with all these documents you have? What are you going to do with them? Very well-educated crowd. All right. Everybody wants to know, I don't want to have to pay any taxes, Steve. I paid enough during my lifetime. Can't you please make it stop when I die? I don't want to pay what we call death taxes, right? Well, quote-unquote death taxes really fall into two categories. An inheritance tax is actually a tax that very few people will ever pay, a quote-unquote inheritance tax, because an inheritance tax is actually a tax paid by the heirs for inheriting. So it's kind of like income tax. All right, so they receive it, they have to pay taxes on it. Well, with most of these taxes, you got state and you got federal, right? Well, there's no Montana inheritance tax. There's no federal inheritance tax. I think Washington has a $1 million. So I think there's less than a dozen states that actually have an inheritance tax. And those states, you can get double taxation because the next tax is what we call a state tax. Now, this is what we need to be concerned about. It's paid by the estate of the decedent. So this is the government taxing you for having the audacity of dying. So they're going to get you on the way out, right? And there is no Montana estate tax. So in Montana, if you're a Montana resident and your kids do not live in a state with an inheritance tax, and if you're wondering what does, just Google, does Idaho have does Idaho have an inheritance tax? Which I believe the answer is no, but I don't know those off the top of my head. In Montana, all we have to worry about is the federal estate tax, okay? And you're taxed, the tax rate of that is 40% of every dollar above the exclusion amount, okay? So this is the only death tax we have to face. So let's talk about the exclusion amount. I want you to think of the federal estate tax exclusion amount as a line, like my arm right here. And this line right here has a number associated with it, a dollar value. When you pass away, if the total value of your estate is below this dollar value, you'll owe no estate tax. If your dollars exceed this line, then you'll pay taxes only on the assets above that line. It's not that you get above that line and it triggers it and that tax is retroactive to zero. It's just if anything above that line is taxed. Well, most people in Montana, they know a story of a family somewhere rancher, farmer, where the matriarch passed away, and the kids had to sell off some of the land to pay the estate taxes, right? We all kind of heard those stories. And that's the reason a lot of people take out these huge insurance policies, even though they could barely afford them, just so when they passed away, they pay the estate taxes, right? Because 40% of it. Well, we recognize that as a problem. When I say we, Congress. And they're noticing big farms, big ranches become smaller and smaller and smaller as it's cannibalized by the taxes. And so what did they start doing? They started raising that exclusion amount up every few years, increasing it higher and higher and higher. See, you go back to the 90s, that number was in the 600,000 range. Let's just call it 650, I believe. So if a farmer passes away and they have a large farm, third generation farm, let's call it a ranch, and that ranch is worth $1 million, even though they got $8,000 in their bank. They got $1 million farm. They have a $350,000 estate tax, and they had to pay, it was close to 40%. All right, so $125,000, $50,000 or whatever, just on that right there. So that's why the kids had to sell off some of the land to pay that. Well, Congress recognized that as a problem, so they started raising it. If you pass away today, does anyone know how much you have to have in assets in order to trigger the estate tax? I mean, what is that exclusion amount today? Does anyone know? Anyone want to take a guess? $12,920,000.
Oh, right under it.
And if you're married, you each get it. So then it becomes $26 million, let's call it. And if the two of you are worth more than $26 million, then why are you here wondering how to pay for long-term care costs? You just buy a place. Matter of fact, buy one here, one down in Arizona. You can switch back, be a snowbird between the two. If you don't think, you say, well, Steve, that doesn't sound right. Well, let's just go through it. I got numbers and facts to back it up. In $650,000, 37%. And it bumped it up, bumped it up, bumped it up, bumped it up. And then in 2018, it doubled. And it keeps going up every year. And the reason that we're now in some kind of funky numbers is it has a cost of living adjustment, so it's a percentage, it goes up.
Are other states like that?
Pardon?
Is this federal or per state? Is this Montana?
This is federal. This is federal.
Right.
And real quick, I'm happy to answer all of your questions, but some of you have not eaten dinner, and if you're like me, you don't want to miss a meal. So let's do this. I put notepads out. If you have a question, just jot it down. And if I haven't answered it by the time we get done, then I'll answer some questions. This will allow those without questions to be able to go out and get something to eat. All right? And we'll get out of here quicker, too. And folks, here's the other thing. Every one of you's got a question, right? I mean, God help you if you didn't have anything better to do than to come here and hear me talk about this tonight, right? And each of your questions are probably personal in nature. Maybe it has to do with a loved one's health. Maybe it has to do with your own health. Maybe it has to do with your assets. Maybe it has to do with a gambling son-in-law. And the only thing worse than asking a question in front of a room full of strangers is asking a personal question in a room where you know 2 or 3 people. And so I've taught these workshops for years, so I'd get the question and the person would say, well, Steve, my friend has a son-in-law that, well, they didn't repay the loan I gave. I mean, it doesn't take long to figure out that we're talking about yourself. And so this is not a good forum to ask these personal questions. So what I started doing a few years ago, and it's worked out great, is if you make it to the end of this presentation, you will have earned the right for a free consultation with me or one of the lawyers in my office. You get 30 minutes, phone call, or you can come in, see us, phone call, whatever you want to do, and you ask your question. And then, because whatever question you ask, I'm probably going to have to turn around and ask you some questions back. Is there a mortgage on the home? Are there any children that are disabled? Does your husband know you have a boyfriend? And so It's just a lot better for us to have a one-on-one confidential conversation, and then I can answer your questions in detail, all right? And so what I will do here in a little while, I'm just going to pass around. There's like a little clipboard that I have that you just, put your name on it with your number, and my assistant will give you a call tomorrow, get you on the schedule, and you ask a question then, all right? So someone asked me recently, they said, Steve, why are we at 12 million? How in the world did we get to 12 million? And my answer to them was, well, I can only guess that that's the average net worth of a Washington lobbyist. Folks, you got to remember, Congress has assets and kids too. Right? I mean, the more hair I lose and the more these hairs change color, the more I kind of learn how the game is played around here. But honestly, this is where we are, and it will be political suicide for anyone to ever try to lower that. Besides, they have no self-interest in creating a larger tax burden for Senator so-and-so's own estate, right? In Montana, less than 1/3 of 1%, I'll say that again, less than 1/3 of 1% of Montanans now will ever face an estate tax, a death tax. So that's good news. No taxes when you die, most likely. If you win the lottery, give me a call. We're going to need to do some estate tax avoidance planning. All right, capital gains tax. We're just going to talk a little bit about taxes just as a foundation for some of the things I want to teach. We're not going to get too far out in the tax weeds, I promise. But we all know what income tax is. That's the tax you pay from your earnings, your wages, or interest earned. Capital gains tax, that's when you sell an asset and you have to pay taxes on the sale of that asset. So capital gains tax formula, let's say you sell an asset you own for $100,000, but you only paid $60,000 for it. So when you buy an asset, accountants are going to assign that purchase price with a name called cost basis. That's your cost basis. So whatever you paid for your home, that's your cost basis. Any improvements you've made to your home since then, not repairs, improvements, that increases your cost basis, okay? And in this simple example, your cost basis here, $60,000, you sold it for $100,000, so you had a capital gain of $40,000. Now, I just use 20 because it makes my math easy, but most it depends on your tax rate, but most people are going to pay about a 25% capital gains tax. You got a federal aspect, you got a state aspect, there's a couple of other things they try to ding you on. But let's just call it 20%. That means you would owe $8,000 in capital gains taxes. So we start thinking about that home you bought 30 years ago. It's a huge capital gain, right? This is important in estate planning. Why? Because there's a huge difference between giving an asset to someone and that person inheriting from you. What is the difference? If you give it to them, that means you're still alive. If they inherit it, that means you've already passed away. Huge, huge tax difference. Where does this come into play? We'll talk about it in a little while or after a while. But I get this all of the time. Steve, I put my house in my daughter's name and I added it to my bank accounts. Didn't I do good? Well, we'll explain why someone would do that. Perhaps it is a good strategy. Perhaps it's not. Tax-wise, here's the big difference. When you give someone an asset, let's say you deed your house into your kid's name today, you give them your cost basis. Right? We all know what houses have done in western Montana over the last 5 years, much less 30, 40 years. So let's say this couple here, they bought their home in 1990 for $50,000. Well, now it's worth $550,000 at least. So if they sold it today, they would have a $500,000 capital gain, right? If they deeded their house into their child's name, that child, let's say then you've passed away and child's like, I don't need a second house. What I need to do is sell that house and pay off my own mortgage here in Boise, right? And when the child sells that house, they're going to get crushed on capital gains taxes, right? Because it's a $500,000 gain. And if it's just 20%, which is probably more, that's a $100,000 capital gain that they're going to pay $100,000 in taxes, probably more like $125,000, $150,000, depending on their tax bracket. Now, alternatively, if you leave your home to your child, same child, in your will. So you've now passed away. They inherit it after you have died. Now they sell it, and the accountant's like, well, what did you pay for it? Well, I didn't pay for it. Well, they got to figure out what's your cost basis. Do you owe any capital gains taxes? They say, no, actually, I inherited it. That was my parents' house. They say, oh, okay, well, when did your parents pass away? 3 months ago. Okay, well, I'm sorry. What's this child's cost basis in the house? They got to figure out. Let's say the child sells it for $550,000. What cost basis is the accountant going to give them? Does anybody know? Date of death value. Excellent job. So, daughter inherits it and sells it within the same year. We're just going to assign the date of death value as the sales price because that's obviously was the fair market value. That was determined by the buyer. So if she sells it for $550, accountant's going to say, all right, cost basis is $550, pay zero in capital gains taxes. See, if you give it to her, she sells it, she's going to owe $100,000 in capital gains taxes, right? Just saved you $100,000. That one's for free. But you see, it's what we don't know that can get us. And I never want the tax tail wagging the estate planning dog, but I want you to understand there's a huge difference between inheriting and giving it. So that's one of the reasons that I kind of frown upon, putting your assets in your child's name for the tax reasons. But in a little while, we're going to talk about a bigger reason we don't want to do that. If you've already done it, it's no big, maybe we let that sleeping dog lie. All right. What asset has the most asset protection and tax advantages that you can own? Anyone want to take a guess? What asset can you purchase that has the most laws to protect the value of it and has the most tax advantages to you for owning it? Primary residence, without a doubt. Remember when I said every law we have passed is designed to support some kind of public policy? Here's a perfect example. Our government wants to encourage home ownership for a number of reasons. I guess philosophically they think, hey, most people are going to buy a home, maybe they'll pay it off, and in their senior years, they're not going to become homeless. They'll have a place that's paid for. But it also supports a huge, huge industry, right? Home builders and such. So we want to encourage home ownership. So what do we do to encourage home ownership? Well, they provide incentives, right? Tax advantages and legal protections of the equity. So, first example, anyone ever heard of a Montana Homestead Declaration? This is designed to protect your home from lawsuits. Has nothing to do with long-term care costs. Lawsuits. And the chance of anyone in this room getting sued is very low, right? But if you're sued, you don't want to lose your home. Now, the reason it's $378,000 is it goes up every year, cost of living adjustment, 4%. A couple of years ago, it was static at $250. Now it's up to $378,000. So let's say that you magically have a home that's worth $378,000. But you owe $100,000 on the mortgage. You also have $100,000 in your savings account and checking and all of that, right? If you're sued, I want you to take that check, that money, and pay off your mortgage. You see what we just did? We took that $100,000. You know what's not protected? This stuff right here. There's no protection. Well, there's FDIC insurance. That's insurance. That's not a law. That's not protection. So what I'm getting at is, philosophically speaking, from an asset protection standpoint, the worst thing you can do is sell your house, convert it to cash. As we begin to talk about paying for long-term care costs, all of this will begin to tie in, right? So, your home, and what is a homestead? If you have a condo and you just closed on it last week, that's your homestead, okay? You don't have to be out working the land. And you do not have to have lived there for a while. And it may, and I put this in italics. Actually, I saw one of the big investment magazines just this week had an online article that said it was about protecting your assets from long-term care costs. See, the words, everybody's doing this now, right? People have been doing it for years, just most people have never heard about it. Well, the article was incorrect because the article said your primary residence is not a countable asset for Medicaid. Well, what do I mean by that? We'll talk about it shortly, but what happens is if you own a home and you go into long-term care, you apply for Medicaid, they're not going to count the value of your home toward the assets you may have. They'll immediately approve you for Medicaid. But then they're probably going to file a lien against the home, and then through a process called Medicaid recapture, the chickens will come home to roost later. So yes, they don't count it initially, but every month they write a check for $8,000 to the nursing home, that lien increases. So you got a tab that's increasing. And all too often when the person passes away, that lien amount is greater than the value of the home at $100,000 a year in the nursing home, right? So just be very careful. But there's things that we can do, and we're going to talk about it in a little while. How I can protect the home so if your spouse dies, you don't have to sell it and move in with the kids, right? But you don't get that on other assets, just the home. Well, you can, but you'll understand later how you do it. Tax-wise, who in here has ever sold their primary residence? Raise your hand. Half the room. More than half. All right, hands down. Now, I want you to raise your hand. Only raise your hand if, when you sold your home, you had to write a big check to Uncle Sam. Raise your hand if you had to pay taxes when you sold your primary residence. Anyone? No one. Why is that? Does anyone know? Section 121 of the Internal Revenue Code says if you have lived in your home for 2 of the last 5 years, it doesn't even have to be consecutive. You could be bouncing back and forth. If you've lived there for 2 of the last 5 years, when you sell that home, the first $250,000 of gain is not taxable. If you're married, you don't have to be married. If there's 2 people, if there's more than one person that owns the home, you each get $250,000. This is another part of the public policy. We don't want people to sell their house and not be able to buy the same in value, right? So back to this couple here. If you're wondering why I used $50,000 and $550,000 earlier, they've paid $50,000 for their home 2 decades ago or whatever, and now they sell it for $550,000. Will they have to pay capital gains taxes on the sale of their residence? No, because we combine. They each get $250,000. They get a $500,000 exemption. So that's the reason that very few of us ever have to pay taxes on our sale of our home. Now, homes have appreciated so much in the last few years. I'm starting to see it. But usually it's with an individual. But I'm seeing it where a couple sells it and they've got a $600,000 gain just because, they paid $80,000 for it. Now it's worth $680,000. Mortgage interest is deductible up to a point. Property taxes are deductible. Necessary home improvements are deductible. Home office expenses are deductible, and on and on and on. So these are your tax advantages that the government gives you as an incentive to own a home. Again, why am I talking about this? Well, first of all, I want all of you to know it. But second of all, I want to drill down to the point. The worst thing you can do in long-term care planning, sell the home, and now you got cash. None of these, there's nothing that gives you any advantage to keeping cash. You might even say inflation's a disincentive to have cash, right? All right, switching gears, probate. Everybody wants to avoid probate. Why does everybody want to avoid probate? I have so many clients who hire me because they just finished probating their parents' estate, and they're like, Steve, I don't want my kids to ever have to go through this. I didn't realize it was going to be a part-time job and take forever and cost a lot of money. Probate is the state of Montana's process for closing the books on us when we die. Now, in theory, it's a good idea because, well, let's look at it this way. Let's say you've loaned $10,000 to your neighbor.
Okay.
Well, what happens if the neighbor passes away? We need to have a legal forum for you to be able to repay before the kids show up and raid the assets and are gone, right? Also, the government wants to make sure that if your neighbor owed any taxes, that the taxes are paid before the kids show up, raid the assets, and disappear. Same thing goes for the credit card companies or the health care expenses at the hospital or any other debt, tax, or expense. That the theoretical purpose of probate is to freeze all the assets until we can do a full accounting. And then hopefully there's enough assets to pay off any existing debts or expenses or taxes. And then once the estate is settled, they'll distribute the assets per the terms of the will. Okay? So that's the purpose of probate. But here's the problem. We got to go through the courthouse, which makes it clunky, lengthy, and expensive. Okay? So if you want to avoid, I tell clients, well, in Montana, there's a statutory minimum of 6 months for probate. Why? Because we've all seen those death notices, in the papers, usually in the Independent. And if you post, so if a client passes away and we're in probate, and I run this notification in the newspaper, I think it's 3 consecutive weeks, you have to forgive me, then what I have done is I have provided notice to the public that someone has passed away. And really what this notice is for is the credit card companies and the bill collectors and the debt collectors and all of that to say, oh, we got to go throw our name in the hat as an interested party in this estate. And so all assets are frozen for 6 months. Now we can get assets out to the kids and the surviving spouse, so they have money to spend things on. But the personal representative, a lot of people call it the executor of the estate. In Montana, we call it the personal representative. The executor/personal representative of the estate is civilly liable for any assets that are distributed before the estate is settled. Okay? So you could be sued. If you're administering your parents' estate and you take some money out to pay off some, or whatever, right? And you come up short paying off expenses, then you're liable for it, right? So theoretically, the assets are to be frozen for 6 months. And the good news is, if a creditor has not arrived within the 6 months, they're forever barred. And we had a case in Kalispell not too long ago where the decedent owed American Express about $7,700. And we kept, they had a lot of bills. They had hospital bills, they had a bunch of bills. Anyway, most of the creditors were coming and, filing in, interested party, and we were getting up to that 180-day deadline, and American Express had not shown up yet. And I said, I don't think they're going to. And sure enough, they missed it. The very next day, day 181, they filed a claim and we were able to bar it because they missed their deadline. So probate is good in that. I mean, you don't want to have an open-ended pathway for creditors to pursue a claim. We want to have a finish line when they could come forward. Well, the problem with probate is I tell clients they're going to average 12 to 18 months. If I get it closed in 12 months, I've done a good job. But it's also expensive. If you hire a lawyer to do it, they're going to average $4,000 or $5,000 if it's not contested. It's somewhere there. And call it 18 months, just to kind of be safe. Maybe we can do it in less. But I tell clients 12 to 18 months is going to run, somewhere between $3,000 and $7,000 on average. It just depends on how many, what all's involved, right? How many outstanding bills are there? How many heirs are there? How much forensic accounting are you going to have to do? So we want to avoid probate if possible. And in order to avoid probate, there's 3 ways to avoid probate. You have to think about it in terms of the assets you own when you die. Either your assets are probate assets or they are non-probate assets. If all of your assets you have converted to be non-probate assets, there will be no probate. Maybe the estate is settled in a week or 2 instead of a year or 2. So the first type of asset that is non-probate is any asset jointly owned. So, common example, a married couple who owns their home as joint tenants with right of survivorship. Same thing if that couple also shares bank accounts. And the reason is when you own something jointly, when the first of you passes away, the survivor instantaneously becomes the sole owner by act of law. As soon as you pass away, now we may have to file some paperwork in order to clean up chain of title and things, but not only do we not need a probate judge to tell us who gets that asset, it would trump what would be in a will. So if you own your home as joint tenants with right of survivorship and you become estranged from your spouse and your spouse has moved out of the house and you create a will that says this goes to my daughter, when you pass away, it does not go to daughter, it goes to estranged spouse. Unless if it's a divorce, there's another set of rules that apply to that. So that's the reason, folks, when the first spouse passes away, we seldom have to go to probate. Why? Because most of the big assets are jointly owned. And it's the real estate that typically pulls us into probate. See, if I buy your house today, we're going to go down to the title company and I'm going to write a check made out to you for the value of your home. And what is he going to do? He's going to sign a warranty deed that transfers ownership to me. So he gets my check, I get the deed. Now I own the home. But if you've passed away, I can't get you to sign the deed, right? That's what pulls us into probate. We got to go into court, get a court-approved deed to transfer the house from you to your heir. So it's the home that typically pulls us into probate. But if you own accounts, if you have bank accounts and stuff and you solely own it and there's no pay on death beneficiary designation, we have to probate that also. Now, if someone passes away and they have less than $50,000 of total assets, then we can avoid probate by a process, it's called a small estate affidavit, and you avoid probate. So if you've had a loved one pass away, and you're like, well, Steve, we didn't have probate. Well, they probably had assets under $50,000, or you skirted the law. So when the surviving spouse, though, passes away, then we're going to have to probate it because they're no longer a joint owner, right? So when the first spouse passes away, typically no probate. Surviving spouse passes away, we're in probate. Number 2, very, very similar. Any asset that you own has a pay on death beneficiary designated, say life insurance. Upon my death, pay this to my spouse or pay this to my kids. And so, as a matter of fact, with life insurance, and oh, by the way, life insurance is not taxable for the recipient. We normally, the insurance companies usually cut the check pretty quickly. The last thing they want to do is get pulled into a probate case. Similarly, most of your financial accounts now will have a pay on death. So if you go open an account, do we have anybody who works at a bank here? A lot of times now when you open a bank, one of the questions on the form you fill out is, you want to list a beneficiary in case you die. And if you do that, then it's going to avoid probate. Just like the joint ownership, not only do we not need a judge to tell us where it goes, it trumps what a judge might tell us in a will. Okay? So if you get all of your accounts with a pay on death beneficiary designated, those will avoid probate. Now the third asset, and this is typically how we address the real estate. The third asset that you can own that is a non-probate asset is any asset owned by a trust. We're going to talk about trusts, folks. Trusts are as simple or complicated as the estate. If you have a simple estate, you'll have a very simple trust. They don't have to be complicated at all. And when I was telling you earlier about so many people hire me so their kids will avoid probate because they just got done administering their parents' estate, we'll take their home and we'll create a very simple revocable living trust. Now the trust owns the home. We'll talk about how it works. It doesn't affect you tax-wise. It doesn't affect your property rights. Nothing like that. It's just now, it's not in your personal name. It's owned by the trust. And it can be very simple. As a matter of fact, it can look very much like a will. So if we've done all of these, there will be no probate. And if we avoid probate, it will pay for your estate plan. If we avoid the $5,000 probate, it'll pay for your estate plan. I mean, you won't be here to enjoy the savings, but what most people don't understand, there's two costs to an estate plan. There's a cost for setting it up, creating the documents, and then there's a cost for administering the documents. So you may pay $500 for the will, but the probate may cost $5,000. And the exact opposite often applies to a very simple trust. Did you know that probate documents are public information? If you're really bored this weekend, Google Jackie Kennedy Onassis' last will and testament. You go down about 2 or 3 entries, and there it is, folks. Which is kind of sickening. But it's. Do you know why it's on the internet? Because it can be on the internet. It's public information. Any kind of court proceeding is public information unless it's been sealed by the judge because there's a minor or some other reason to seal it. So if you pass away, your nosy neighbor could run down and say, hey, I need to see the Miss Johnson probate files, and she could just finally get all into your business and see exactly what you had and where it went. Now, I'm not trying to scare anybody, but there are predators out there that read death notices and pull the probate files. I'm not necessarily saying it here in Montana, but there's people out there who prey on people who, maybe young people who inherit a lot of money or elderly people who are taken advantage of. Okay? So I don't have anything to hide personally myself, but I don't want any of my information public, right? So that's another thing to consider, is that if you have a probate hearing, it's not, in Montana, it's not that we're in front of a judge. If it's contested, or if you have 3 years to file a probate after someone passes away. If you do that and close it within 2 years, then we're not standing in front of a judge. We're just filing documents with the district court. But if it's contested, if it's been more than 3 years, then we are in front of a judge, and then it does get expensive. So, why is all of this important? Oh, here's the other thing. This doesn't fit well in here, but I put it here anyway. Beware of blended family planning pitfalls. Let me tell you a story to illustrate my point. I had an assistant that used to work for me, that she grew up in Bozeman. She and her sister grew up in Bozeman. When they were very young, like toddlers, they lost their father. Okay, when they were in high school, their mom remarried. And when they remarried, husband number 2, he also had 2 daughters, but they were grown and adults and out of the house. He sold his house and moved in with their mom. And he took the sales proceeds from his house, he put it in the bank, he added her as to death to his part, and so she was a owner of his bank accounts, and so she added him to the deed of her home, and so they were relatively equal in assets, right? And they created what we call reciprocal wills, which a reciprocal will is where you typically with a married couple that says, hey, if I die first, everything goes to my surviving spouse. But if I'm the second one to die, then it all goes to our kids equally. So each spouse says that, so it doesn't matter who dies first, right? That when the second dies, everything goes to the kids equally. Well, here's the problem with that. Well, let me finish the story first. So they were in high school when Mom remarried. So you guys can kind of get the idea here. Here's a guy who moves in this house with 2 teenage girls. They probably didn't roll out the red carpet, I'm guessing. Maybe they did. She was a sweet lady that worked for me. Anyway, when they were in their early 20s, they lost their mom. So everything passed to husband number 2 because they owned everything jointly. Number 1 there. So husband number 2 owns the house and all the bank accounts. He has no legal obligation to leave these 2 girls anything. Now he can. Or he can change his will and think, you know what, those girls they were pretty nasty to me. I kind of like my own daughters more than those 2. And he can change his will. Or maybe he remarries and does the same thing again. So there's nothing that legally requires. See, with a married couple who have the same biological children, the second spouse is not going to disinherit the kids, right? I mean typically, sometimes. But it can be a big difference with a blended family, right? Where maybe you don't even know the kids that well. So with a blended family, wills often fail to serve the purpose. So you go back to this couple right here. These girls' dad, all the assets he owned end up going to his husband-in-law, not his daughters, right? So that takes us to this next slide, difference of a will and a trust. And the short of it here is if you're in a blended family, you have any concern about maybe your kids getting disinherited if you die first, then you need a trust, not a will. Again, wills are easily changed. If you die first, your betrothed could change the will and leave it to, I don't know, some gold-digging tennis instructor. Who knows? So, wills and trusts. There's pros and cons to each. Folks, all a legal document is a tool. And it just depends, what is the job? That will dictate which tool we use, right? If we're hammering a nail, we need a hammer. If we're getting a divorce, we need a divorce petition, right? So a will, a trust, these are tools. So we got to identify what is the job. That'll tell us whether we need a will or a trust. Okay, so it's not a blanket statement that everybody needs a trust. No, maybe all you need is a will, or maybe you need a trust. The pros of a will is they're easy, simple, and cheap. You might even be able to do it on your own, but be very careful that these oftentimes create huge headaches to administer. I have a colleague here in town that the firm, the clients end up racking up over $10,000 to straighten out a $99 will. Okay? So, hey, I'm just like you. I want to say, I don't want to pay any more for anything than I have to, but just be careful. Some of these free documents you're getting what you pay for. Just be careful. I had a $77,000 estate here in town. $77,000. And there was a home. So it was minuscule, right? It took us almost 2 years and close to $10,000 to settle that estate because it was a handwritten will. And anyway, I won't get into the details, but my point is just you get what you pay for usually. But most people go with a will because maybe they know a lawyer and they'll get it done for $500 or less. Maybe they do it for free. Maybe they print off some forms and fill it out. What they're failing to understand is the cost of the probating of that will. If you don't own a home, all you need is probably a will. You don't need a trust unless you got some complex distributions. The downsides of a will is it's got to go through probate if you own real estate and if you have probate assets with a will. The only way you can validate a will is in probate, folks. A lot of people think, hey, I got a will, I'll avoid probate. No. The only way, wills are governed by probate law. The only way I can validate it is get the court to validate it. That's called probate. Also, any child will get their full inheritance at age 18. And this is more important when I'm dealing with my younger parents, meaning parents of minor children. Maybe this couple doesn't have a lot of assets because they're just early in their working career, but maybe they got a couple of toddlers and they got $2 million of term life insurance. Well, I can only speak for myself, but it would have been a really, really, really bad idea for me to inherit $1 million at 18. I doubt I would be here tonight. Why? Because I'm a human. And I mean, how many people at age 18 can manage $1 million? I mean, an 18-year-old thinks that they'll never have to work, right? They don't look at it as, oh, that's only $50,000 a year for 20 years. And so they think it's limitless. Plus, we want our kids to make some mistakes with small amounts of money before they ever make mistakes with large amounts. But you know what? It's not necessarily the kids that I'm concerned about with my clients. It's the people around the kids. It's the girlfriend, it's the boyfriend, it's the spouse, it's the best friend with this great business idea. Disregard the fact this guy's never had a good business idea in his entire life. So, or maybe it's the person that they're riding with no car insurance or whatever the issue is. I'm more concerned about the people who surround the heirs and the heirs themselves. Now, sometimes we got to do a little parenting from the grave. And sometimes we have to do that with a 58-year-old child that maybe it doesn't make sense for them to get a big chunk of money at once. But particularly with young kids, don't rob them of their goals and dreams. Okay, you want to leave $100,000 to your grandchild? Hey, let's stretch that out over a decade or allow them to pull from it to pay certain expenses like college or a wedding, or as I tell my clients, first wedding. We don't want to incentivize a professional bride, and so forth, or whatever values you want to attach to the assets. And the wills only address the probate assets. They don't address the accounts with a pay on death beneficiary designation. They don't address the life insurance policy. Okay, so a lot of times the will really hardly controls anything. If the property's jointly owned, or every retirement account, you've got to have a pay on death beneficiary designated, right? So if you say in my will, I want to leave my IRA to Charlie, that doesn't matter. This is what I mean by this trumps the will. Again, any kind of contract supersedes the will. Okay, because you signed the contract before you died. Will doesn't go into effect. It's valid and legal. It doesn't go into effect until you die. All right, so let's hop over to trust. What are the pros of a trust? Well, first of all, they avoid probate. They're administered privately. Why? Because they're governed by contract law, not probate law. It gives one set of distribution instructions for all the assets. So sometimes what we're trying to accomplish is we want to create a funnel. So that IRA, the bank account, the real estate, whatever else, it all funnels into one place that says to be divided 50-50 to each child. I'm not a fan at all when you say, all right, I'm going to leave the house to this child and I'm going to leave my IRA to this child. Or this property over here goes to this kid, and this property goes over to this kid. Or this bank account goes to this kid, this bank account goes to this kid. Why? Because they're seldom the same value in the future. You may have already drained and closed one of those accounts and never got around to changing your will. Or maybe this house has tripled in value where this one actually went down for whatever reason. Okay, so if your goal, now I mean sometimes obviously it makes sense to state, all right, this child gets this particular property. Maybe they live next door and they work the land or what have you. That makes complete sense. But if you're just trying to say, all right, I want the kids to inherit equally, I'm going to give them this child this thing and this child this thing. Remember that the values fluctuate daily. And just because they're of equal value today does not mean they're going to be equal value in the future. In 30 years from now, I can almost guarantee you one will be worth more than the other. But with a trust, we can say, all right, it doesn't matter, 50% to child A, 50% to child B. Let's just funnel it all in here. We sell everything, liquidate everything, and we write checks. Or they keep the cabin in both of their names, or leave it in the trust and still use it. So it just gives us a lot more flexibility. Also, it offers great asset protection for your kids, not you, from future divorces and lawsuits. Okay? So, back to this couple here. We got this $550,000 home, and let's say you got $50,000 in the bank. So we got $600,000 estate. They have 2 kids. You're going to leave it to them equally with the will, 50-50. Or let's just say there's one child. So you're going to leave this one child $600,000 of assets. And that child might be the most responsible CPA in the state of Montana. But if that child inherits that $600,000, and then tomorrow or the very next day, child is driving down Reserve Street, gets a text, looks at the text, looks back up, and takes out a van full of trial lawyers, what happens to that $600,000?
It doubles.
It's gone. It's gone. What if 6 years later, 2 years later, 12 months later, child goes through a divorce? There are certain protections legally for inheritances, but you got to go argue it in court. Usually when you argue it in court, the lawyers are the ones that inherit. Most divorces are a negotiation, right? So, alternatively, let's say this couple here has just a very simple revocable living trust. We put the house in there, and the bank accounts went in there either while you're alive or when you passed away, pay on death to trust. Now the trust has $600,000 in there of assets, whether the child sold the house or just still owns the house. And child says, all right, I'm going to pull out $50,000 because I need to pay off some debt. I just want to get ahead. I want to take a little time off work. I just want to get a little leg up on life and catch my breath, deal with mom and dad's passing. And it's driving down Reserve Street, takes out the van full of lawyers, and is sued. So she inherited $600,000 through the trust, but she only pulled out $50,000. How much will she lose in that lawsuit? Anyone want to take a guess? $50,000. Here's the number one rule in asset protection. I did it for a long time. If it's in your name, you can lose it. If it's not in your name, you probably won't. Now, the legal reasoning behind this is there's no guarantee she'll ever receive what's in that trust. She might just let it sit and leave it to her own kids. Or maybe she is tragically killed the next day. So there's no guarantee she'll ever receive it. That's the legal reason they can't get what she has yet to inherit. Whatever she pulls out is on the chopping block. Until she pulls it out, it's not hers. It's the trust. Now, maybe it's a lake house. I tell clients, well, you want to keep it, right? You don't want to sell it, or do you? No, we want to keep it. Well, leave it in the dang trust, especially if there's 3 kids, because you're now at 3 times the risk of a divorce or a lawsuit. Especially if one of the kids is on marriage number 8. There might be a 9th. And so I just tell them, leave it in the trust. See, with probate, I got to pull all assets out within 2 years. I got to settle the probate in 2 years, or the judge gets extremely mad. And I can't close probate till I've distributed all the assets. So most probates, the kids, the heirs, they get the assets within 2 years. Well, what if that child's in the middle of a lawsuit? Then it's probably going to hit their account, and the creditors are going to attach it, depending on what type of lawsuit it is. But what if daughter here's in a lawsuit or divorce, and she's got this $600,000 sitting in the trust, or maybe the lake house? I'm going to say, don't even think about pulling it out, right? Leave it in there. You settle your lawsuit, settle your divorce, then pull some money out. So here's a misunderstanding that far too many people believe is you can't take your assets, put it into a trust, and all of a sudden those assets be protected from lawsuits. Can't do it. Why? Because they were in your name and you tried to get them to, well, say you tried to hide them, whether you were intentional or not. Okay? That's a huge, huge difference of your child who did not put it in the trust. See, they never had ownership of it. They never had control of the asset. And they'll never have control. Well, they can control the trust, but until it goes into their names, they can't lose it, folks. So, if I'm dealing with some family land that we want to keep in the family for a while, just say, man, leave it in the trust. So, as a matter of fact, we have a lot of family properties that we talk to the client. The client says, I want it to stay in the family for at least 10 years after I die. Or the kids can't sell it, but once all the children have passed away, a majority of the grandkids can vote to sell it. And what did we just do? We kept that family cabin in the family for one more generation. So with trust, you can do that. With a will, 2 years. I got to get it out. I get it out in 2 years. So that's the downside of a trust. Downside of a will. I have a client. He's a professor at the university. He's in his 80s. And 30-something years ago, his father in Michigan left him a couple $100,000 in this revocable living trust. And so I was meeting with him some time back, and I said, what do you want to? He was kind of changing up his estate plan a little bit. I said, well, what do you want to do with that? You want to leave it like it is, or do you want to just take that out and put it in with some of your other accounts in your trust? And he said, and now that $200,000 is worth close to $1 million because he's never pulled anything out. He just left it in. It's in mutual funds and stuff. He just lets it grow. He's done pretty well for himself. He doesn't need that money. He's just going to leave it to his kids. He's got his own money. But I asked him about that. He said, no, Steve, that's my sleep good money. And what he meant by that, wise old professor, was that he knows that he could be over there getting a car wreck or whatever and get sued and lose everything in his name. But he can't lose what's in the trust his father left him because he has yet to receive it. So it allows him to sleep good at night, knowing that he's got a $1 million safety net just in case. But he's going to leave it to his kids anyway. But that's a perfect example of what you can do with a trust that you can't do with a will. Bloodline clauses. Back to this scenario. So they're going to leave it to their daughter, the $600,000. But before she pulls it all out, she passes away. Well, would you rather your assets go to your grandchildren or her spouse? Grandchildren, right? Spouse, in-law, got his own family. They can do their own planning, right? And besides, what if spouse remarries? Now it's gone not to the in-laws, but the outlaws, right? So with a trust, it doesn't, if child dies and there's still money in the trust, it doesn't go to spouse unless you stipulate that. You certainly can. I had some people do that. But typically, if child dies, there's still money in the trust, or if child dies with you, then it goes to the grandkids, a bloodline clause, okay? Cons. What are the downsides of a trust? It requires more work and planning up front. We're going to have to retitle some of the assets to get them into the name of the trust. I'll have to create a deed that transfers your home out of your personal name and into the John Smith Trust or whatever. Don't worry, it's no big deal. If you got a mortgage on your house, the mortgage will travel with the house and into the trust. Okay? It's no big deal at all. We create the deeds, we file the deeds at the courthouse, boom, now your trust owns your home. And I put it's more expensive than wills initially. Why do I say initially? Because I'm considering the cost of administration of the estate. Just so you'll know, I quit doing billable hours years ago. The only time we ever do billable hours really is for probate cases because we have no idea how long it's going to take, how much work's going to be involved, or who's going to show up and say they have a claim on the estate. So we have to do billable hours because you can't predict what it's going to take. For estate plans, I've done this long enough. I have a pretty good grasp of what it's going to cost to do this kind of work. So I kind of have a fee schedule based on the complexity of the case. But on average, in Montana, if you hire a reputable attorney to create just a simple revocable living trust for you, and if they're going to do the trust, they're going to do, remember all the estate documents I listed, they're going to do your powers of attorney and your living will, so you have everything, right? I consider it malpractice to just do a will or trust. You need all of that because the one document you don't have, rest assured, that's the one we're going to need. So I'm talking about the full binder full of documents, all right? So an estate plan, not a will, not a trust, an estate plan, everything you need. On average, in Montana, a simple revocable living trust-based estate plan, most law firms in the state, now it's going to vary depending on how simple or how complex. If you've got 3 different ranches and you own properties in 4 different states, obviously it's more complex. But for on average, let's just say it's a married couple, they got their house and they got a couple $100,000 in savings or whatever. And they got 3 kids, the kids are going to get it equally. So very straightforward. The entire estate plan, typically, they'll be somewhere between $2,500 and $3,500 on average, something like that. Call it $3,000, give or take, right? If you have more assets, a little more complex, it might bump up toward $4,000, right? So what does it take to administer it? If we got our ducks in a row, I've had some fairly complex estates that we administered in 2 weeks. So if the kids hire me and I work for 2 weeks, do you think that costs less or more than me working for 18 months? So that's what I mean. Oftentimes the trust will actually pay for itself by avoiding the probate. If the trust is improperly done and poorly funded, it will cost a lot. Okay? That's the reason that you want someone who has done it multiple times to do it for you. You don't want people learning on your dime. All right. What is a trust and how does it work? Well, I think it's helpful to understand, all right, what's the parameters here? How many parties are involved in the trust, right? So there's only 3 parties to a trust, regardless of how complex or simple it is. There's only 3 parties to a trust. First party is called the grantor, also known as the trustor, settlor, and a number of other words. Most estate lawyers refer to it as the grantor. Who is the grantor? Well, let's get back. Well, I'll come back to that. The second party to the trust is called the trustee. Trustee. And the third party to the trust is called the beneficiary or beneficiaries. So you got three hats. Somebody's wearing the grantor hat, somebody's wearing the trustee hat, somebody's wearing the beneficiary hat. And there may be multiple grantors, multiple trustees, multiple beneficiaries, but there's 3 parties to the trust. Back to the grantor. Who is the grantor? The grantor is the one who hires the lawyer to create the trust. And what they're creating is a trust agreement. This is the tool. This is the legal document. The trust agreement. The trust agreement says, all right, here's who's in charge when I die or become incapacitated, and these are the people who are to inherit, and this is how they're supposed to get their stuff. So then, remember I said, then I got to create a deed or do some work. We're going to grant into the trust some of your assets. So I don't want you to think of a trust as having any value. It's the assets that the trust controls that has value. So think of the trust as this box. The value is what you put in the trust, your home, your savings, okay? So the trust in and of itself is just the paperwork. You don't sell a trust. You sell the assets owned by the trust. All right, so we've created this trust agreement. Someone's got to be in charge of it, right? So you've hired me, I've created this trust, and now I've put your home and I put your bank accounts in the trust. Who's in charge of all that? Well, you are. You're the trustee in this case. The trustee enforces the trust agreement, so it's no different than owning assets in your personal name. For instance, if your home and your bank accounts are in your personal name today, you've got complete control, right? You want to sell your home, sell your home. You want to spend your money, spend your money. You're in control of your assets. That's the exact same thing as if you create a trust, you put your assets in the trust and you're the trustee, right? You got the checkbook, you want to sell your house, you want to refi, buy a new house. It doesn't matter. What's important is when you pass away, right? What happens to it? So I tell people, when you put your assets into a trust, you lose no property rights, you lose no legal rights, you lose no tax advantages. When we're doing a revocable living trust, it's called a grantor trust, which means it doesn't have its own separate tax consequences. It all passes through the trust and it ends up on your personal tax return, which means you're not going to pay any more in taxes or any less in taxes. It's tax neutral. Okay? So there's really nothing to fear about a trust. You don't lose control. Now, if you said, I don't want to be trustee, I want my child to be trustee, then the child is actually in control. But you could always call me and say, they didn't do what I said, fire them. But 99% of the time, if I'm doing a revocable living trust, whoever hires me to do it is the grantor and the trustee. If you're married, there's two, you're co-grantors, co-trustees. First spouse passes away, surviving spouse is the sole trustee. Still in control. Okay? Now, when the surviving spouse passes away though, or if you're an individual and you pass away, who's in charge? It's called the successor trustee. Who is the successor trustee? Whoever you would name as the executor in your will. If I die, I want my eldest child to manage my affairs, or I want my children jointly to administer. That's your successor trustee. They have no control until you quit serving as trustee. So when I said there's three hats, there's the grantor hat and there's the trustee hat. But you may be wearing both hats while you're alive. And then if you become incapacitated or die, the trustee hat comes off your head and goes to whomever you've designated to be your successor trustee, whoever you would name as your executor in your will. And when we put assets into the trust, that's called funding the trust. When the assets come out of the trust, they go to whom? Well, who are we doing this for? We're doing this for the benefit of your kids, your heirs. I know not everybody has kids. I know not everybody loves their kids. For simplicity, we're just going to say everybody's got kids. You're leaving your kids tonight. I don't want to drag this thing on any longer than we have to. All right, so the kids are the beneficiary. So you fund the assets in, and then you distribute out of the trust into the kids. Here's the power of a trust, the distributions and the flexibility. Folks, people hire me for a revocable living trust for two reasons. Number one, avoid probate. Number two, it gives them some options on the distributions. Now, it could just serve actually, most trusts that I draft are very much like a will. Kids get it when I die. Here's the difference. The kids are not required to pull it out when I die. They can, but if they want to leave it in for a while, they can leave it in. With a will, they got to pull it out within 2 years, right? So as we've indicated, there might be reasons to leave things in the trust so they'll never lose it. Their sleep good money. But you can also say, you know what? This particular child I have concerns about their financial wherewithal, and I would like to leave them a certain amount of money every year for, say, 10, 20 years, just to make sure they're never broke. Or maybe son has been successfully sober for 3 years and we don't want to rock the boat. Maybe this particular child, they love them as much as the other children, but their spending is only limited to their credit limits. Or perhaps it's who they married. Or maybe it's a young person, and you just say, you know what, I want them to I want the trustee, which is probably, another family member, trustee can pull money out of the trust for this child for college or yada, 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 or $1,000 a month until they're 25. And then at 25, they can get 1/3 of the principal. They still keep getting the $1,000 a month. And they turn 30, they get another third. So you can do all kind of things with a trust you can't do with a will. But most of the time, we just say, all right, kids have the right to pull out all their inheritance immediately. And then when we're administering trust, kids come in. I'll say, all right, this is what your parents have set up. Here's your options. And sometimes one kid will pull out their share, and the other kid say, leave it in there. I really don't need it, but I am going to pull out 50 grand or 25 grand, and then I'll just keep pulling out when I need it. And that child understands that they can't lose what... Okay, if it's still in the trust, what does that mean? Does it have to be in cash? No. A lot of times some kids will say, well, I want to get my money out because I want to buy a rental house. I want to buy an investment property. Well, you can do that. You're now the trustee. You take your cash in your trust, go buy that house, and now the trust owns your rental property. Or you want to just put it in mutual funds or government, folks, U.S. Treasuries are paying 5.5% now. I'm talking 3-6 month Treasuries. So whatever the kid wants to do with the money, they can still do the same thing with it still in the trust. The difference is they can't lose it. I had a child, they inherited a lot of money, and they always wanted a lake house. And they spent the entire fortune buying the lake house, and fine. But I said, don't pull the money out and then go buy it and put it in your name. Just take all that cash in that trust, buy the lake house, and now you can't lose it. You can still use it, whatever, rent it out, keep it, enjoy it, live there. It's no different. Just you can't lose it to that van full of trial lawyers, right? All right. So 2 reasons we do a trust. Number 1, void probate. Number 2, I'm talking about a revocable living trust, very simple trust. Void probate, and it gives the kids some options. Or maybe you need to do a little parenting from the grave and say 5% a year for 20 years, 10% a year for 10 years, whatever. Or they get X amount of dollars until age 50. Whatever you want, you can make up your own rules. Cabin can't be sold until 20 years after I die. All right. Types of trust. Now, I teach this different than most because it's not theory to me. I mean, I'm actually boots on the ground. I work in this every day, and I try to communicate in very basic layman terms, right? So, I visualize trust 2 types. First, I want you to think of in terms of time-related. Time-related. What do I mean by that? When was the trust created? And you got 2 options. Either it was created during your lifetime, meaning you hired the lawyer to create the trust. That's called a living trust because you were living. Or there's a testamentary trust. This is created by the grantor's will upon death. So you get in there in the will, you get over there to page 6, and it says, a trust will be created for my children. I cannot stand testamentary trusts. Anybody want to take a stab on why I detest? So if someone brings me in that will, says, here's my will, I want to update it, and I look over there, not only do I see the personal assets on page 3, earrings to Susie, but I get over there to page 6, and it says the trust will be set up for my spouse, children, what have you. Now, anyone want to take a guess why I cannot stand when I see that? What did I say the first reason, the first benefit of a trust is?
Avoid probate.
Avoid probate.
Wills are in probate.
What do I got to do with a testamentary trust? It's in a will. I got to open probate. Then set up the trust. So one of two things, either the lawyer didn't know what they were doing or the lawyer was creating future work for themselves. Here's another thing. So let's say that this couple's combined assets are $1 million. They got life insurance, real estate, the whole deal. They got $1 million. And I already told you that, trusts are going to be $2,000, $3,000, $4,000, somewhere in there, right? And you come into my office and you say, all right, we have these children. I want to do this and this and this and this and this. All right, be glad to help you. It'll take us about a month and it's going to cost you $20,000. Well, if he's polite, he's just going to tell me to pound sand, right? Why? Because you know that I'm bilking you. You already know it's going to be $2,000, $3,000, $4,000 tops. And I say I'm going to do it for $20,000, right? So he has control over the cost. He can get up and walk out, right? What if I create this $500 will with a testamentary trust in there and he dies, they both die, and the children come to me all brokenhearted and grieving, and I say, well, yes, I can do this. I can help you out. We got to open up probate, and that's going to run you about $5,000. Then I'm going to sit, I said, the good news here is, within 12, 18 months, we'll have it all settled. It's going to cost you about $5,000, but that's the state law. Whatever, we've got to go to probate. And then I got to set this trust up for you, and it's going to be really cool because you can leave those assets in that trust, and they'll be protected from lawsuits or divorces. Oh, that sounds good. What is that going to cost? Oh, about $20,000. So the kids are thinking, all right, well, that's going to be $25,000. That means I get $975,000. Okay, I guess that's what it costs, right? They can't tell me to go pound sand. This is what it's going to cost. They could, but usually when they're grieving, what's what it's going to cost? It's going to cost $25,000. All right, well, thank gosh we got money to pay for it, right? See, that's the difference. I want you to be able to say, no, you shyster, right? Kids are not going to call me a shyster unless they come to one of my workshops. But obviously I'd never do that, right? I was down in Phoenix at a continuing legal education camp. It was a 3-day estate planning course. I was the only lawyer from Montana there. And it was about all these different types of estate planning strategies, rules, updates in the law. And I remember we were on break between two of the sessions, and I couldn't help but overhear these two attorneys behind me. They were not from Montana. I was the only one. They were talking. Of course, I couldn't help but overhear them, and I heard this one guy behind me tell the other guy behind me, he said, I never do trusts. I only do wills. And the other lawyer said, well, why? Because I'm thinking, what the heck are you doing here? He said, and this is what the guy said. He said, because all those wills I do, that's my retirement plan. Though I wanted to, I did not choke him. Because that's what gives us lawyers a bad name, right? It's those kind of guys, shysters. And he's the same one that's going to do the personal property, probably everything, right? That would increase his chances of having to amend the will. And then he creates the complex, very probably overly complex testamentary trust. And so that's what he was saying. He spent the first 20 years of his life probably creating 1,000 wills so he could spend the next 20 years of his life doing $10,000 probates. So, I'll get off my soapbox here, but you're starting to kind of see a pattern, right? You want to control things yourself, and you want to get them done yourself. You don't want to kick the can down the road. Besides, even if I charge market rates, what's going to cost more? Me doing a trust today or me doing it in 20 30 years from now, assuming that I'm still capable of doing one in 20, 30 years. It's going to cost more in the future, right? If you have a will that's got a testamentary trust in it, I'm not saying that the person who drafted this for you, was trying to bilk you or whatever. Maybe they don't do very many wills or trusts, and that's how they were trained when they were a young lawyer, to do it this way. And that's oftentimes the case. But there are some individuals out there that create future work for themselves in the legal work that they do. All right. So time-related, living trust. If you're going to get a trust, get a living trust. And we're going to talk about revocable and irrevocable. Either you can have living trust, it's revocable living trust, irrevocable living trust, it's while you're alive. Don't have it set up in your will. I had one come in this week. I had this conversation. Steam was going out their ears by the end of the conversation. Protection related. Protection related. So trusts provide protection to two classes of people. A revocable living trust protects the beneficiaries, not the grantors. Right? We talked about this. You can protect your kids from lawsuits and divorces, not yourself. If the asset's already in your name, you can't hide them in a trust and be protected from lawsuits. If that were the case, no one would ever write a check at the end of a lawsuit. There would be no lawsuits. Maybe that would be a good thing. But if that was true, anyone that was sued would just simply create a trust, put their assets in there, and they'd say, good luck. But we can protect for our children. Now, irrevocable trust protects the grantor and the beneficiaries. However, the grantor does not get lawsuit protection. They get nursing home cost protection. It has nothing to do with lawsuits. I want to be very clear here. We're about to shift gears and start talking about how to protect your assets from long-term care costs. So, revocable living trust does not provide you protection from long-term care costs. An irrevocable trust does. An irrevocable trust does not protect you from lawsuits. It will protect you from long-term care costs. Folks, let's discuss this word irrevocable. That sounds really scary. It sounds very permanent. It sounds like a tattoo. You do it once and it's there forever, right? I have never drafted an irrevocable trust that does not have a trust protector clause. What is a trust protector clause? That's the clause that says, for any unanticipated events in the future, the grantor can hire a trust protector, i.e. the lawyer who drafted the trust, to change the trust. If I create an irrevocable trust for you, you can't change it. You can't pick it up, take your pen, scratch through it, and write something else and initial it. You will have revoked it. You will have converted your irrevocable into a revocable. But you can call me and say, Steve, I need to appoint you as my trust protector, and we need to make some changes, right? For whatever reason. And then I can make those changes, and you'll sign a document saying that you authorized me to do that and all of that. And then, I'm going to have to ding you for a couple $100 or something. So don't let the word irrevocable scare you. You can still change it. Also, if you want to get the asset out of an irrevocable trust, you can. Sometimes I don't want you to. Sometimes it's ill-advised. But it has to be done a certain way. But I can get assets out of the irrevocable and back into your name. It's just got to be done a certain way. You don't have to hire a lawyer to break the trust, as they say, right? You can undo it. It's just got to be done a certain way. Also, if I create an irrevocable trust, you can be the trustee, just like with a revocable living trust, or you can appoint your kids. Sometimes when we're doing the irrevocable trust, it's for elder clients, perhaps, that they're like, you know what, I'm already kind of handing things over to my kids, and they're going to be the one in charge, and there's really not much for them to do anyway during the rest of your lifetime. Sometimes it provides greater protection if you don't serve as the trustee. But I'd say about 10% of the time, the grantor is the trustee on the irrevocable trust. And the other times, we're probably naming a kid, and you're just telling the kid what you need done. Okay? See, when you name the kid or whomever to serve as your trustee, you have complete control over them. You can call me up the next day, say, I want to replace them with this person. Done. And we invoke the trust protector clause, and I pull out this child and I put in another child, or your sibling or whomever. Also, let's say that you own your home. You're like, all right, Steve, I want to protect it from nursing home costs. I don't want to have to sell my house and move in with the kids. So I put it in this trust, and then 3 years later, you're like, I don't want to shovel snow anymore. We're moving south. Well, can you move? Yes. You can sell that house, and what you did, let's say you sell your house for $400,000. Now, remember, the trust is just the box. It's not the assets in the box. The trust has no value itself in terms of financial. It's the assets in it. So the trustee can take the assets in the trust, and convert them into other assets. An example, let's say all you have in your trust is your home, and you want to move or whatever. All right, you sell the home. Now the trust has cash. That's not a change to the trust, folks. Trust still says, when I die, this is in charge and this is where it goes. It's a change of what's in the trust. So a change of trust assets is not a change to a trust. Now, you go find your replacement home that you're going to buy. And you write a check out, or the trustee writes a check out of the trust for the new home, and that home comes into the trust. And so now the trust owns real estate again. That is not, we have not changed the trust. You could even, let's say you sell your $500,000 house, and you go down to Arizona and you buy a $300,000 townhome. What happens then? Now you had a $500,000 house in the trust, and now it's $300,000 of real estate and $200,000 of cash that you can invest. Steve, I want to buy some furniture. Fine. Write a check out of the trust, go buy your furniture. Steve, I want $5,000 in my pocket. Okay, we got to do it a certain way. We can get money out of the trust. All right. So, as you can see, you're not really losing any rights, tax advantages, anything like that when you're using this irrevocable trust. You want to change it. If you change your trust, you'll make two changes. Here's the two changes you'll ever make to a trust. See, folks hardly ever change the trust because we think a change of assets is a change to the trust. No. All the trust is going to do is say, when I die, this is in charge and this is where my stuff goes. 25, 25, 25, 25%, whatever. Regardless of what's in there. So, here's the two changes you'll make to a trust. Number one, you want to change who administers it when you die. Maybe one of your children gets sick or has died or ticked you off. You call me up and say, hey, this is my successor trustee, not them. All right, that's your first change. Who you want to administer it. Number two, how the beneficiary or who the beneficiaries are or how they inherit. So if you want your two kids to inherit 50-50 and you never change your mind, you will never call me up to change the beneficiaries. You might say, I'm writing this kid out. That would be a change. So if you never change who you want to administer, if you never change how you want your kids to inherit, it's not a change to the trust. Therefore, you're not even going to have to invoke the trust protector clause. So we have to work within the rules, but we're trying to create it as user-friendly as possible. Why do I use an irrevocable trust to protect you from long-term care costs? Because in the Medicaid manual, it says the assets owned by an irrevocable trust may be non-countable. And in a revocable living trust, they are countable. That's the only reason I'm using the irrevocable, is because I want to work with the Medicaid manual. So what we're doing with, and lawyers refer to it as a Medicaid Asset Protection Trust. Oh, thank you. Are we passing that around? Let's make sure we start in the back so we don't miss anybody. This is the little sign-up sheet. I was going to flash it here in a second, but you guys are ahead of your time. So, what we're doing with a Medicaid Asset Protection Trust is we're taking the Medicaid manual and reverse engineering that into a trust so that if you ever get ill and we need to apply for Medicaid, the trust sings the songs that the Medicaid manual wants to hear. Make sense? So we're creating this specifically to convert your countable assets to non-countable for Medicaid. All right, how do we do that? And let's talk, let me lay a foundation of retirement. We've all heard the recipe for having enough money in our retirement years. Whether it's Dave Ramsey on the radio or Susie Orman on TV or the latest, greatest financial services book, right? The process for putting away money and having enough to live on during retirement is relatively straightforward and simple. As a matter of fact, Warren Buffett said, if you can't explain to me an investment on the back of a cocktail napkin, I'm not interested. And his point is, good investing is not complex investing. It just takes time. Simple things that you can understand. So retirement planning, the formula goes something like this. Make consistent earnings during your working years. You don't work, you're not going to have anything in retirement, right? Pay yourself first. You've heard that, right? What they're talking about is create a consistent pattern of savings. It does not matter, when you get a paycheck, it doesn't matter how much you put away, it's the habit. Maybe you just put 1 penny away. But the point is if we can teach our children to get in the habit of putting a little bit away. Every time you get something, it's a habit. And then sometimes maybe they get a windfall and they can put a lot more, right? But it's the habit is more important than the quantity. But create a habit of savings. Live off the rest. Investments. So once you have enough in savings, we want to diversify, right? We don't want all of our eggs in one basket. And what I mean by that is, well, Dave Ramsey talks about mutual funds, right? You instantly are diversified over hundreds of companies, perhaps, instead of having all your money in Enron or Silicon Valley Bank. And then you want to hire a prudent tax preparer so that you're paying no more in taxes than you legally owe. And if we do all of this through our lifetime, let's represent that as a castle. You also heard it referred to as your nest egg. Let's call it a castle. So this castle would include Social Security, maybe a debt-free home, and then maybe anything that you've saved or in your retirement account, whatever. And if you live within your means, folks, you're going to be fine. And I'm still at heart, I'm an asset protection lawyer. I see this differently than your financial advisor or a CPA or the general philosophy on investing. See, most investment in personal finance is all about maximizing your rate of return, ROI, return on investment, and we want to avoid taxes. Well, that's all well and prudent. But my firm has served over 3,000 clients at this point, and probably half of those I met with myself. And I've met with a lot of people that didn't hire me as well, or a few, most hire me. But my point is, I've seen well over 1,500 portfolios where people come in and say, hey, this is what I have, Steve. This is where I want it to go. So I've seen literally thousands of what people are doing with their money. And maybe it's very modest, maybe it's complex. I see a glaring problem with 99% of the portfolios that come to my desk is everybody's focused on this right here. Everybody's focused on building the castle. And I look at it from my perspective, which is different, and I see something that's missing. You know what's missing? Whether it's one story or multiple stories, hardly anybody's got a moat around their castle. What do I mean? Well, let's say you got a $500,000 castle and you have a stroke. 5 years later, it's all gone at $100,000 a year. Okay? So you could do everything right for 40 years and lose it in 4 or 5. Or be like my grandmother, who worked her tail off for 40 years and lost 80% of it. Right? So, what do? I'm a ditch digger. I dig moats around your castle, if this is what your goal is. How do we dig a moat around a castle? Well, it really breaks down into 3 categories, and I don't do all of them. Your first line of defense, whether you're sued, you're injured, you're going into long-term care, you're in the hospital, is always insurance. If your house burns down and you have enough insurance, you can rebuild, right? Your financial problems will go away. So that mayhem guy from the Allstate commercial shows up. If you've got enough of the Allstate, you're going to be back to where you were before, at least financially. Number 2, LLCs and corporations, limited liability company. And as the name implies, it limits your professional liability or investment liability from your personal assets. So what we're doing here is we're building a firewall. Remember back to the construction worker. I want to set it up so if through his work he is sued, he may lose the company, he may lose all of the equipment, the machinery, the trucks, and all. He could lose all of that. But if we've done this correctly, he will not lose his home, he will not lose his personal savings, if it's done correctly. When do you use an LLC? When do you use a corporation? That answer will be given to you by your accountant. It's a tax question. They both serve the same goal. It depends on your situation. Most of the time people are buying rental property. All we need is just a simple LLC. So let me walk you through an example of how we layer the onion. So let's say that you have a rental house here in town. She owns her personal residence, and her primary residence is in her name solely, but she also has a rental house that maybe it was her previous home that she kept and she rented out to college students. Both are in your personal name. Now tomorrow night, Friday night, those 2 young guys throw a party over there on campus in your rental house. And one of them ends up at the bottom of the stairs paralyzed. Uh-oh. We got a problem. And so, long story short, the handrail on her stairs is not up to code. As a matter of fact, you don't even have one. You've been thinking about replacing it, but you just haven't got around to it yet. Or maybe there's a little rod on the stairs. You are a negligent landlord. But for your malfeasance, this young man would be walking today, right? And so what are the trial lawyers going to do? They're going to circle like buzzards. And, not only is this 21-year-old college student faced with a lifetime of pretty serious health costs, he's also got a diminished lifetime's earning capacity. So let's say each one of her homes is worth $500,000. And you got another $500,000 that you've saved. So she's worth $1.5 million. And I just make up a number. Let's say they win the lawsuit against this negligent landlord here, and that's $2 million. Well, what are we going to do? Well, the first thing that's going to happen is she's probably going to have about $500,000 of liability insurance on that rental house. They'll cut a check for that. But that's $1 million deficient. So what are they going to do? They're going to go after everything that you got to satisfy that deficiency judgment. So they're going to get both of her homes if she has not filed a declaration of homestead. If she has, we protect the first $370,000 or thereabouts. But then they're just going to go after your cash. So you could quickly see how she could lose everything. Why? Because the rental house was in her personal name. Remember the number one rule in asset protection? If it's in your name, you can lose it. So, since she came to my workshop last year, and she came in the following week, and one of my attorneys created Johnson Street LLC. And we put her rental house in Johnson Street LLC. Primary residence is still in her personal name. Same scenario occurs. What happens? Well, the liability insurance company cuts a check for $500,000. That's deficient by $1 million, and they go after every asset the owner of that rental house owns, which is the rental house. And if done properly, that lawsuit ends at the four corners of that house. You lost your rental house, but you kept your savings and your primary residence. Now, what if she has 3 rental houses? We're going to have a serious conversation about maybe we need 3 limited liability companies so one domino doesn't take out all 3. And folks, unless you have investment partners, an LLC is very simple, very, very cheap. I mean, we set them up for anywhere between $500 and $1,000, and it's going to cost you about $20 a year to keep it maintained with the state of Montana. So, if you got 3 different rental properties, we're probably going to do it for, maybe $1,500. And now all 3 of them are out of your name. And if one goes down, the other 2 are still standing. So that's how we kind of layer the onion. Same thing if you have a little business. What if you got a little part-time daycare in your house? What if you got a little part-time tax preparing business that you do? Or as one of my clients who asked, well, it wasn't a client, she was a client afterwards, but she was up in Kalispell. She came to me at the end of the workshop. She said, Steve, I don't know, I'm thinking I might need an LLC. What do you think? I said, well, tell me what's going on. Well, she told me where she lived, and I realized instantly she was a multimillionaire where her property was. I know the place. And I said, well, what are you doing up there? She said, well, I teach horseback riding lessons. No risk there at all. Never been anybody bucked off a horse and landed on their head besides me, has there? So I said, yeah, you might want to consider. And so if you're dealing with someone's children or their money or their health, maybe you want to create a firewall between that activity and all of your assets, right? So anyway, that's how we use LLCs, corporations to do this. Folks, if they didn't work, no one would do them. They wouldn't exist. Right? But it's got to be done properly. I've seen some that fail because they were poorly done. And then third, and this is where our focus is going to be on the rest of the evening, estate plan. That's your third way to dig that moat. And what I'm talking about is protection from your single greatest threat of invasion to the castle, which we have identified as long-term care costs. Yeah, if your castle's going to get plundered by a barbarian horde, it'll be the barbarian horde of long-term care costs, most likely. The chance of any of you getting sued is very, very low. Why? Because we've reached the age of wisdom. And we're just not as active as the 20-year-olds. All right. This is my reminder to say, hey, I want to pass around the sign-up sheet. On these 2 right columns, if you need to grab it and recheck it real quick, I want to be able to know, I want my attorneys to be able to know, what are we going to talk about on the call? If all you want to talk about is, hey, I need a will or a trust, I don't know which one, or Steve, can you dig a moat around my castle? Then just check estate plan. If you have a loved one that is either in long-term care or facing that in the near future, and you want to know, hey, can we save any assets and qualify for Medicaid? I want you to check Medicaid crisis planning. And if you need to change the way you fill that out, just hold tight. We'll get it back around or whatever, okay? All right. And so name, address, email, Pearl, my assistant, will call you tomorrow or leave a message for you, and we'll figure out a time that works on your schedule. All right. Let's talk about the cost of long-term care. This is in Montana. Let's just talk about the two primary sources of long-term care: assisted living and skilled nursing care. Assisted living, it averages $50,000 a year. It doubles for skilled nursing care. This is your entry fee. You need extra bells and whistles, it goes up from there. So you can quickly see this is your single greatest financial risk. I have a client that I've helped her. Unfortunately, I couldn't help her mother. Her mother has been in the nursing home for 17 years. In my mind, I'm thinking $1.5 million. So, but it's never the real cost. And why? Because we're probably going to have to sell some assets or go earn some wages to pay for it. Remember when I said that my dad and my uncles were writing checks for my grandmother for a period of time? Well, in today's dollars, if they were going to write checks for $100,000, they are probably going to have to go earn 130, right? Because they get the taxes withdrawn. Same thing. If we're going to pay for Dad's long-term care with his IRA, well, when we start pulling money out of the IRA, what do? We've got to pay the deferred taxes. So unless that money is actual cash in a bank, which cash is not taxable, you pull it out, you spend it, then you're probably going to be cannibalizing assets, and the real cost is probably going to be 130. What if you're selling land? You say, all right, well, we're going to sell this land just like my family did. Well, you got to pay the capital gains taxes at 25%. So that's what I say. It always costs more. The 100,000 might look a lot more like 130. So instead of 1 million in 10 years, it's 1.3 million. How long are we in a nursing home? It really breaks down into about approximate thirds. The first approximate third are in for a year or less. The next approximate third, people are in for 1 to 3 years. So these people are, if it's skilled nursing care, this group right here, $100,000 to $300,000 is what you're on the hook for. And then the next approximate third is for 3+ years with nearly 1 in 5. 5+ years. This group right here, $500,000 or more. That's 1 in 5 is what they're facing. So you can quickly see why this is your biggest financial risk. Now, how can we pay for it? There's 4 options on how you can pay for long-term care. So there's 4 doors this guy's facing. First door, pretty straightforward. Savings. Grandma has enough in savings? Well, then we write checks. Number 2, long-term care insurance. I already told you I'm a big believer in insurance, but here's the problem with long-term care insurance. Well, the big problem is no one has it. But the second problem is that it's usually a supplement to your savings, because either it doesn't pay everything per day, or it only pays for a limited time, like 24 months. So I see policies all the time, something that, all right, this policy will pay up to $200,000, or this policy will pay up to 18 months, or there's always a limitation, right? It's just not an open-ended policy. And so what if we're in for more than 2 years? Well, then the policy runs out and we're back to saving. So if you've got it, I applaud you. If you don't, I'm going to teach you a much, much cheaper way to create alternative form of long-term care. Now, door number 3, this might seem pessimistic and depressing at first. Let's try to see the glass half full. If you have a loved one and they have very few assets, and they have a stroke or dementia or whatever the scenario is, you may be under the wrong impression that the only way that you and your family can care for that loved one is to provide that care yourself. That's not true. If your loved one has very few assets, I can quickly get them qualified for Medicaid, and the Medicaid will pay for all of their care without limits for the remainder of their life. But they're most likely have already run through most of their assets. Now, it's important to note here that there is a distinction, a legal and healthcare distinction between healthcare and long-term care. Medicare is healthcare. Medicare is not long-term care. Medicare will pay, the first 100 days or days, 21 through 100, whatever. If the patient goes into the hospital for 3 consecutive days and is discharged to a long-term care facility, Medicare will pay approximately the first 100 days. It's just considered an extension of the emergency health care. But on day 101, you become a long-term care patient. Medicare quits paying. Now, Medicaid, on the other hand, has 2 departments because of this reason. One department is for health care. So this is kind of typically what most of us think about as Medicaid. Single mom, couple kids, she can qualify for Medicaid. Now she has public health insurance for going to the doctor, hospital, what have you. There's very, very little an attorney can do to help someone qualify for health care Medicaid. It's very black and white. Either you qualify or you don't. There's not much I can do. Long-term care Medicaid, on the other hand, there is a lot that I can do based on these laws passed to support these public policies. Okay? So that's the reason Medicare does not pay for long-term care, but Medicaid will, because there's a separate department. And the qualifications are separate types of qualifications. So it can be very confusing. You might read, how do you qualify for Medicaid? And you pull up this Google article and it's just limited to healthcare Medicaid. It has nothing to do with long-term care or vice versa, right? There's a 4th door. Most people are completely unaware of the 4th door. They only know about these 3. And if you knock on that door, an elder law attorney answers it. Says, come on in. And what do? We use the laws afforded to you that you're probably unfamiliar with to protect some of your assets so you can qualify for Medicaid, or your loved one can qualify for Medicaid without ever having to go broke. So door number 4, use elder laws, asset protection laws, to protect and preserve as much of the assets as legally possible. And then we apply for Medicaid. We've heard of a spin down. How much do you have to spend down before you qualify for Medicaid? So if we do this right, we're going to try to minimize that spin down. Maybe there's a little bit of a spin down, maybe there's a lot, but you'd be surprised how much we can save. Let's talk about how do we do that. Well, we do it 2 ways. The first is what we call proactive planning. So proactive planning means we're being proactive, right? That means that it means that my client is healthy. That there's no immediate need for long-term care. But they're saying, Steve, I want you to dig that moat around my castle just in case my husband has a stroke, so I don't have to sell the house and move in with the kids. That's proactive planning. The other way that we do it is called, it said crisis planning. For whatever reason, I can't back up on this presentation, but crisis planning. So the first type was proactive planning. The second is called crisis planning. Crisis planning is when the healthcare need is already here. Perhaps our loved one is already in the nursing home. Maybe they've been in the nursing home for 2 years, and the child calls me up and says, Steve, I can do the math. We're going to run out of money next year. Or Steve, my wife's dementia has reached the point I can't do this anymore, and I don't even know what questions to ask. So in those cases, as in a crisis case, we're not being proactive. It's all hands on deck. Let's save every asset we can. All right? Let me first dispel some myths about Medicaid. This is the primary reason I began teaching these workshops, is just to clear up. There's a lot of bad information out there about Medicaid. Here's the first myth. Steve, I don't want mom to be in a Medicaid facility. We're just going to pay privately, so I don't want her in one of those Medicaid facilities. There's no such thing as a Medicaid facility, folks. The fact is, 2 out of every 3 Americans in a nursing home pay for it with Medicaid. It is not the exception to the rule, it has become the rule. It's not that all of these people were broke. It's that they went in and after 3, 4, 5 years, they ran through all of their money. And once that happens, someone at the front desk fills out a Medicaid application. So, if 2 out of every 3 Americans is in a Medicaid facility, That means only 1/3 of the facilities out there are private pay. Just doesn't add up. You want to see a Medicaid facility? Drive by most. Now, some, their demand is so high in certain communities, it's a supply and demand issue, where, maybe they're primarily private pay. This is what you're going to hear. We don't accept Medicaid patients here. Well, how does that square with what Steve just told me? There's a difference of not accepting Medicaid patients and not having Medicaid patients. Remember what I just said? Medicaid pays about 70% of what private pay is. So if this facility has 2 open beds, they want to hold those open for someone to come in and pay privately. But they don't want more empty beds. So if someone comes in privately and they go through all of their money, then they're going to apply for Medicaid, and then Medicaid will pick it up at that point, and they'll go from getting 100% to 70%. They'd rather have 70% of something than 100% of nothing, right? So that's the reason that they may say we don't accept Medicaid patients. So how do we dance that dance? We go in paying privately, then we run through our money, and we plan this. We find enough assets to get where we want to go in paying privately, and then we implement the Medicaid strategy. If they're going to create these rules against us, we're going to figure out a way to dance through their evil dance, right? So these are the laws. You got to know how you got to protect yourself and your family by knowing these laws. So don't ever think about a Medicaid facility as some substandard facility. Every place pretty much is a Medicaid facility in that regard. And there's another one, and I get this mostly from you guys, you tough guys. Well, Steve, my family's not going on Medicaid because we don't accept welfare. We don't take charity, it's a handout, right? You guys have heard it before. Sir, have you reached the age to receive Social Security yet?
Yes, sir.
Just barely crossed it, huh?
Just barely, yeah.
Do you consider that welfare or charity?
No.
Why is that?
Because I paid for it.
You paid for it. Then are you also on Medicare, sir?
Yes.
And I know that you probably pay something for it, but you also get a little bit of a discount as opposed to private. Uh-huh. Well, is that charity?
Nope.
Why is that?
Because I paid for it.
Guess what else he paid for? Where do you think all this Medicaid money comes from?
The government just has it.
There's a tree. There's a tree in Washington with Medicaid dollars. Folks, every time you pay a check or get a paycheck or file your taxes, depending on how you pay your taxes, you've paid into the Medicaid bucket. Just like your Social Security, just like Medicare. It's not a handout. Look, all Medicaid is a required public insurance policy, and it's like any other insurance policy. You get a large group of people pay a little bit of money, and then you get a small group of people pull out a lot. Don't be afraid of using Medicaid as your emergency long-term care insurance policy. You've been paying the premiums all your life. It's just hopefully you're never going to have to cash in the policy, right? So don't be afraid of using this or having some ethical qualm. If so, don't complain to me about paying too much in taxes. You're paying for this. This is the reason it's here. And that's just all that says. That's the fact. We've all paid for this policy. I just hope none of us in this room need it. But if you do, don't go broke. Use the policy you've paid for. How do you qualify for long-term care Medicaid? Well, you got to check 3 boxes. First box, you got to be age 65 or older, blind or disabled. Well, if we're looking for long-term care, we're probably going to check that box by default. Second box, you got to have trouble with 2 of your activities of daily living. Usually it's a mobility or a memory issue, or maybe you can't get around too well. You can't do your own cooking or cleaning or whatever. So that's what gets us in assisted living. So why would we be applying for long-term care if we didn't need help, right? So we're going to check the age in the health box automatically if we're, again, trying to qualify for Medicaid for long-term care. The third box This is where everybody fails. You got to have less than $2,000 of countable assets. This is where most people fail. Now, folks, I know that we've been going long. This is where I want you to wake up. If you elbow your neighbor, wake up, wake up. If you leave here with one thing tonight, this is it. This word for you in the back does not say total. It says countable. You can only have $2,000 of countable assets. So your brilliant legal mind there, I can see the wheels turning. What's countable, what's not countable, right? And that's what elder law attorneys do. We take your countable assets and we legally convert them to non-countable. I tell my clients, listen, the worst thing you want to do is lie to the government. You don't have to cheat, lie, or hide things. Let's just do it right. And you don't have to look over your shoulder, look, I love all my clients. I'm going to jail for no one. And we got all these laws, and so let's just do it by the book and be very, very transparent about it, and it'll go just fine. I have a secret weapon that works for me. Her name is Joyce. I had the great fortune of meeting Joyce 5 or 6 years ago. Joyce is a retired Medicaid fraud investigator for the state of Montana. She spent an entire career sniffing out people who were lying on their Medicaid applications or trying to defraud the government with Medicaid fraud. So she knows what raises a red flag. She's seen it all. She knows what raises a red flag, but she also knows what's generally accepted strategies, right? And she's just a wonderful lady. And so she was bored in retirement. There's only so much gardening you can do. And I said, how would you like to review every one of our Medicaid applications and give me the thumbs up or thumbs down? Oh, I would love to. And she is wonderful. So whenever we have a client, it allows us lawyers to be very aggressive with our asset protection strategies. And then we submit the proposal to Joyce, and she goes through it, and she says, looks good. Or she's going to say, Steve, you're poking the bear here. This is going to trigger a denial audit or worse. And so because of that, I mean, knock on wood, our applications are just generally never turned down because we know what to present to them. We every I is dotted, every T is crossed. We don't try to submit something that Joyce says will not work. And by this point, we've learned through Joyce what works and what doesn't. But still, I want her to look at everything. So that's the reason you don't have to try to be deceptive. You just got to do it the right way. You got to find the laws that work for your situation. All right. Now, remember when I said we do this proactive planning and we do crisis planning? Even though you didn't get to see the word crisis because I can't go back on my slideshow. Let's talk about proactive planning. So this is you calling me up and saying, hey, Steve, dig a moat around my castle just in case. Who in here has ever heard of the Medicaid 5-year look-back period? Anybody? Oh, a lot of you. So what the Medicaid 5-year look-back period, this is Medicaid's attempt to prevent fraud. Meaning they don't want Bill Gates to take all of his assets, put it in his kid's name on Monday, and then Tuesday go qualify for 15 years of long-term care paid by Medicaid, right? So what Medicaid says is, all right, any gift that you made in the last 5 years is countable. We're going to assume you made that gift solely to qualify for Medicaid 4 years later. But if it's been more than 5 years, we don't count it. It's really, really big. So in proactive planning, we're working with a 5-year look-back period. Now, if you're trying to do this on your own, saying, all right, I want to give my house away for at least 5 years so it's non-countable, you have two options. You typically, remember when I was talking about, I hear this a lot. Hey, Steve, I put my house in my daughter's name and added to my bank accounts. Okay, let's talk about that. There's two reasons someone would do that. Number one, it will avoid probate. There'll be no probate. Why? Because they don't own the home. Kid already inherited it. The second reason is if I do that, if someone did that in 2018, then if they fall ill, they'll qualify for Medicaid because that house will be non-countable. Why? Because that gift was made more than 5 years ago. But your other option is to create a Medicaid asset protection trust. We'll just call it an asset protection trust. They both have downsides, but either way, what you're doing is you're getting the home. Sometimes we're doing more than the home. It just depends on your situation. We're getting it out of your name. We're counting 5 years, and then that's no longer a countable asset. It will not have to be liquidated to pay for your care. It will go to the kids or whoever you want it to go to. It will not ever have to be sold. All right, they both have downsides, these two strategies. What's the downside of putting it in a family member's name? Well, the first one is there's bad tax consequences. Remember the scenario here? They take their $550,000 home that they paid $50,000 for. They put it in daughter's name today. They pass away, daughter sells it. Boom. She owes $150,000 in capital gains taxes. So I just want you to be aware of the tax consequences. We would rather daughter inherit that. So if she ever sells it, she doesn't end up paying taxes. But let's not worry about the taxes. Here's a scenario. What if you've put your house in your daughter's name 3 years ago, and she takes out a van full of trial lawyers tomorrow? You're homeless. So number two, they could lose it in a divorce. They could lose it in a lawsuit. Why? We already established the number one rule in asset protection. If it's in your name, you can lose it. If it's not in your name, you probably won't. Well, if it's in daughter's name, she can lose it. Folks, never, ever, ever put your assets in someone else's name. Now, if you're in this room and you have done that, and it's been 4 years or more, let's let that sleeping dog lie, because you're pretty close to your 5-year look-back period. You tell your kid to get a bunch of liability insurance and prenuptial agreements, or whatever, you know. If you go down to the courthouse and look at all the unhappy people, which are most, the people who are getting sued, getting divorced, filing bankruptcy, wearing an orange jumpsuit, the vast majority of those people are between the ages of 18 and 50. And the statistics show after age 50, it just drops off. And the reason is, not only have we acquired that rare nugget called wisdom, we're just less active, right? So if a 65-year-old parent puts their home into their 35-year-old child, not only have they lost control of the liability, they've exposed it to probably twice the amount of liability. Anybody in here been married more than 30 years? Raise your hand. Anybody more than 40 years? Whoa. You are on Social Security. Has anybody in here been married more than 50 years? Oh my gosh. 55 years. 60? 58? 57? 56? How long have you been married, ma'am? What did she say? 59 years? And for the rest of tonight, she will be teaching us on how to live life. Congratulations. And for all of you. So, you guys have been married for how long?
56.
Congratulations. That's awesome. You have children?
We do.
How old is your youngest child?
49.
49. 56 years. You know what? I think this marriage is going to take. I'm not going to ask your age, but who's at a greater risk of being divorced? 56 and going strong, or 49 years old. Yeah, I think you guys are going to make it. So you see my point, right? You take it out of your name and you put it into a child's name. Not only have you lost control, you've exposed it to greater risk, right? Who do you think drives more, them or their children? Well, I don't know.
They both live in big cities, so they do.
Yeah. And they're surrounded by a lot more traffic than you.
Exactly.
Right. So who's at a greater risk of being in a car wreck, right? They are. Just, And, the younger they are, then that means they got kids. They may be running to and from ball practice and everything. Just more active, going to and from work every day. So just be very careful. Now, like I said, if you've done that, that's okay. I'm not saying it's bad news, but just you got to be aware of the downsides. Okay? There's another downside is, let's say they have done that 3 years ago, and he tragically has an accident tomorrow. Can I get him qualified for Medicaid? No, because within the last 5 years he made this big gift. But you call me up, I can cure the gift. All I got to do is deed the house out of daughter's name back into your name, and now we've cured the 5-year problem. But if you put that house or money in daughter's name and she lost it in a divorce or lawsuit, I can't get it back and cure the gift. And this is the only time I cannot get someone into a long-term care facility. Why? One, they lost all their assets because daughter got sued. And I can't qualify them for Medicaid because they made a big gift in the last 5 years and they get this big penalty period. So if I can't cure the gift, I can't get you qualified for long-term care Medicaid. So no. If you're 4 years into it, just go ahead and try to be cool and safe and tell children, hey, let's be careful. Your other option is to hire an elder law attorney and create that Medicaid Asset Protection Trust. So what are we doing here? All right, instead of putting in daughter's name, I create this trust that says, upon your passing, all your assets go to daughter. Daughter will administer it. Okay. We start the 5-year clock ticking. After 5 years, it's a non-countable asset. Well, you know what the trust doesn't do? It doesn't get married. It doesn't get divorced. It doesn't drive cars. It doesn't start businesses. It doesn't get sued. Remember, that trust is just that box. And then, so you've put your house in this trust. If daughter gets sued or divorced, do you lose your home? Of course not. It's not in her name. When you pass away, it comes out of the trust and goes into daughter's name. She gets the step up in basis. She does not pay the capital gains tax if she ever sells it. So what we've done as lawyers is we've created this to avoid all of these downsides. And folks, this happens more than you would believe. Happens more than you would believe. What's the downside? Few attorneys are trained to do this, and if they don't do it correctly, the results can be disastrous. For example, this young lady right here calls me up tomorrow and she says, Steve, I don't have time to go into it, but I really need a DNA-based murder defense.
How did you know?
How did I know? I saw that twitchy eye. If she calls me up and asks me for a DNA-based murder defense, best thing I can do is get you some tickets to Mexico. I am not the guy. You get Johnny Cochran in the dream team. And my point is that's a very special type of law, right? Same thing if you want a patent or if you've got a big water law. Okay, I'm not the guy, right? You got to find someone not only who does nothing but that, but that's been doing it for a decade or so, right? That they're not learning on your dime. Same thing. You don't want the guy who did, or the gal who did your divorce to create a Medicaid Asset Protection Trust with a pour over will provision with enhanced powers of attorney. Right? So you just got to be very careful. If you want an attorney to do this for you, ask them how many times they've done this, right? If they've done it less than 12, Folks, all joking aside, I had a guy call our office in July, and he and his brother inherited the family farm just north of Billings. And it's about a $3 million farm. And they're not wealthy people. It's just been in the family for a long time. They're stewards for this generation, and it passes on. Well, a guy called me up. He was mad as a hornet. What happened is his brother had a severe stroke, had to go into long-term care, and they had hired a lawyer several years ago in Billings to set up a Medicaid asset protection trust, just in case this ever happened, they wouldn't lose the farm. And they applied for Medicaid and they were denied. And the attorney that drafted for them no longer practiced. So they called our firm and said, hey, what is going on here? We got denied for Medicaid. We got a Medicaid Asset Protection Trust. It's been in there for almost 10 years. I said, send me the trust. They sent me the trust. First paragraph. Well, I don't want to use their name. The John Doe Revocable Living Trust. First paragraph. It's not a Medicaid Asset Protection Trust. They hired a lawyer to do this, and the sucker just did a revocable living trust for them. And they relied on this person. So here's the good ending. It just so happened, it was based on just the dynamics of the family and the scenario. We were actually able to get that. See, the brothers owned it 50-50. We were able to get 50% out of the sick brother's name into the well brother's name. He had to pay some money for it, like he had to do a purchase agreement. But we saved the farm and he immediately got qualified for Medicaid. We can't always do it, but certain cases we can do it. So Medicaid's paying for it and they kept the farm. But they should have never had to come to us, right? So just be careful. If you need a DNA-based murder defense or a Medicaid Asset Protection Trust, find someone that's done it a few times prior. Crisis planning. Okay, so the 5-year look-back period, we primarily use with proactive planning. I get it out of your name, we count 5 years. So October 2028, that's your finish line. And while we're on that, let's just talk about that. A lot of people are under the wrong impression that if you don't make it the full 5 years, then it doesn't work. No. So if we set that up today, what's today, the 4th? Let's go with the 4th. The 5th? Let's go with the 5th. If I set that up for you today, got the house in there, that means your finish line is October 5, 2028. I've instantly limited your exposure to the nursing home to 5 years. That's the most you'll ever face. And then every year that goes by, every day that goes by, that 5-year waiting period shrinks. So now, 3 years later, he's been in a car wreck. You call me up. What can we do? I'm going to say, well, we're still 2 years away from the 5-year finish line. Maybe we're probably going to do some crisis planning, but their maximum exposure is 2 years. How old are you, sir?
72.
72. You look young. I thought you were. At a meeting like this, 72 is young. So this gentleman may live another 20 years, maybe 30 years. Who knows? Let's just go with 20. That's kind of average once we get a certain age. I mean, living in the 90s is nothing anymore, right? And so without anything in place, he could be facing up to 20 years. Let's say you're in a severe accident or something. He could be 20 years in long-term care. You have no limitations except your life expectancy. But if I set this up in year 3, you're limited to 2 years. And then so all we got to do then is we got to figure out, how do we pay through this 2 years? Well, maybe we borrow a little against the house. Maybe we liquidate the retirement account. Maybe we talk to the kids and say, listen, this is your inheritance. You need to pitch in. Or we might say, how are you going to pay for it anyway? Right? And so even if you only make 3 years into your 5-year plan, you're still limiting your exposure. You're still limiting your exposure. So, not that I advise people canceling their insurance. I have a lot of people that had long-term care insurance. It pays for 2 years. And once we get through the 5 years, they cancel their policy because they don't need it anymore, right? Now, I'm not advising you to do that. It would be poor, that would be bad advice, but I've seen it happen. I'd rather you have that insurance and not need it than need it and not have it. Crisis planning. All right. What are we talking about here? We don't have 5 years to work with. The need is now, or the need is going to be in the next 6 months. Here's the client's already in the facility, or that need is imminent. Folks, here's the good news. It is easy for me to save 50% of the assets. Easy, 50%. So, client calls me up, mom's in the nursing home, going through her money pretty quickly. How much is left? $200,000. In my mind, I'm thinking I can save at least 100. 50% is easy. Sometimes we get 100% like with that farm. So, and I even tell, look, I don't want to overpromise and underdeliver, so I say 50%. That's on the low side. So it's never too late. Even if your loved one is already in the long-term care facility, we can still probably save at least half of what they've got. If what they have left is their home, I might be able to save it all. It just depends. So how do we do that? Well, remember, every law is based on a public policy. There's exceptions to the 5-year look-back period, which allows me to transfer assets typically to the kids or the well spouse, and then maybe out of the well spouse into a trust. There's a number of ways to do it. But here's some of our most common examples. If there's a disabled child, so disabled child could be 58 years old living in Florida, but on disability. If there's a disabled child of the Medicaid applicant, I can transfer the primary residence to that child immediately, not subject to the 5-year look-back period. What is the public policy there? We want to take care of our disabled population. If there's a disabled child, we will allow, because honestly, oftentimes that disabled child is living in that home, or will be. And so we want to preserve that. So we don't want to just have 2 lives crash. At least we want to take, so disabled child, and like I said, they just have to be on disability. I have a client whose son, there's a son and a daughter, and the daughter came to see me about her mom. And we were talking about this, and I was asking about her brother, and she's like, well, he can't work, and all. I said, is he on disability? She said, no. She said, I'm sure he'd qualify. It's just, he doesn't want to go through all the trouble of applying. I said, we're applying immediately. And he got on disability, and I was able to transfer about a $580,000 home into his name. And then mom's wishes was for the home to go to both of them. So once it went into his name, I then matter of fact, we created both deeds, 2 deeds. We filed them 1, 2. First deed went from mom to him. That made the exception. Second deed went from him to he and sister 50-50. So we honored mom's wishes that both kids inherit the house, but we saved the house. If we hadn't done that, they were going to have to sell the house to pay for her care. So that was pretty cool. Very similar. If there is a in-home child caregiver, it's not uncommon for one of the children to move into the house to take care of their parent. You got to do it for 24 months prior to application. So we got another client. She's been in, I take it back, it's a son. Son has been in the home for 18 months. I was like, we just got to pay for 6 months. And then I put because that's really all they had was the house. Well, it was maybe $40-something thousand. I said, just stay. We got to stay there in the home, and we're going to get some in-home care. We're going to get there, but once we can get through, that 24th month, and mom was okay. She wasn't in the nursing home yet, but we knew it was going to be in the near future. So we just 6 more months in home, and then we'll go, and then we were able to do it. But we do this quite a bit. I had one client whose daughter was a nurse. She lived in Michigan. This was down to Bitterroot. It was a house on 40 acres, so it was $700,000-800,000 home because of most of the land. Well, she went home. Both of her parents needed care. She moved back to her parents. She actually put a little manufactured home on the property, and we were able to transfer the whole property into her name because she had been there for over two years caring for her parents. Oh, and guess what? Both parents had to go in. And you don't get a 2-for-1. $15,000 a month for both of their parents. But we were able to transfer this $700,000-800,000 home into her name, and we did the same thing. She had a sister. We then transferred it from her to her and her sister 50-50. Immediately got Medicaid to pay for both of her parents $15,000 a year, a month. Okay, so those are just a couple. Caregiver agreements. What we can do here is we can take the applicant's cash and, well, I don't want to get too far out in the weeds here, but we can basically hire the child to be a caregiver to go by and see them at the rest home so many hours per week. And so it's just like if the family hired a visiting angel to go by and visit, maybe, take them out for lunch or just to kind of hang out and be companion care, really. Maybe do a little work inside the home or whatever, just kind of hanging out, watch the Mariners game, what have you. We can also hire the child to do the same thing. And we can take that cash, set it aside, and we pay the child to do that same care. That cash that we set aside is based on the life expectancy of the applicant. It's basically an early inheritance. So there's a lot of cool things that we can do. Next one. This is extremely complex. It would take me hours to explain this. This is what I want you to understand. If I can use a Medicaid compliant annuity, that strategy alone, I can save 50%. I can't use it in every case, but often, probably half the cases we can. 40% of the times we can. What is a Medicaid compliant annuity? It's not an annuity you get from your financial advisor. It has to be designed by an elder law attorney based on the life expectancy of the person. And then we have a financial company out of Wisconsin that they underwrite these things. They specialize in these. And it's basically a way for me to save half the cash. So it might be a situation where, hey, maybe we have an in-home child caregiver child. I put the house in the child's name. All right, now we're left with $100,000. We take $50,000, we put it in here, and the spend down is $50,000. And then maybe I create a $35,000 caregiver agreement. And now our spend down is now $15,000. So we want to try, and folks, these are just some of the most common ones. The list would go all the way down the floor. So what we're doing, it's not a one-size-fits-all. What we do is like when we're hired in a crisis case, we do what's called a full case analysis. It takes us 2 or 3 weeks. And Joyce is involved. One of my attorneys, Stephen Colas, you may be working with if you guys ever need our help. He's probably the state authority on this now. He's probably the state authority on this. And so what we do is a practice Medicaid application, and we implement, and we scrutinize. All right, what is unique to this family, and which laws can we go grab and utilize? And how many of them can we utilize? So we may not use any of these with your family. We may use all of them. It just depends. And so we examine the applicant, and then we go find whatever works and cobble together the best strategy we can. And the more strategies we combine, the closer I go from 50% to 100%. All right. And I hope that gives you hope. Okay? This is what I mean that if I had the time machine, I could literally save my family's farm. All right, last slide. You guys have been great. I know we went way over tonight, but you guys are just fun to talk to. A lot of funny comments. Okay. My favorite thing to do is to play Santa Claus with the VA's money. There's the least known VA program out there is called the VA's Aid and Attendance Pension. This program, and the reason I'm sharing this with you is maybe you know somebody we can help. This is limited to wartime vets. As this program is defined, that's one day of active duty during a recognized conflict. So first day of boot camp could have been the last day of Vietnam. That would be a wartime vet for this program. This program is old. It was signed into law by Abraham Lincoln at the end of the Civil War, and it was because of the Civil War that they implemented this program. So it's only for wartime vets. But here's the good news. Most of the vets that we know that are on VA disability, that is a service-connected disability. Maybe it's Agent Orange. Maybe they lost a limb. Okay? So they're getting disability based on something that happened while they were serving. For this program, it has nothing to do with service-connected disability. It's just the wartime vet now walks with a cane, or has arthritis so bad they can't tie their shoes certain days, or maybe their memory's fading, or maybe they have COPD. So it's not that this person has to be in a nursing home. As a matter of fact, one of the great unanticipated benefits of when we started doing this program is how many vets I've kept in their own home because I could get them qualified for this, and all of a sudden they have newfound money. And you've got to check 4 boxes. The first is you got to be a wartime veteran, honorably discharged, 65 or older, and suffering from some health issues, activities of daily living. And there's some asset limitations, but here's the good news. I can take if they own home, which is usually what makes them over-resourced, I can put that into a certain type of trust, a VA-compliant trust with no look-back period, and that comes off their countable assets. But if we can qualify, if we can get all these boxes checked, here's the benefits for 2023. A married vet, I can get $31,000 annually. That's paid like $2,600 a month. Tax-free. From the VA to the vet is tax-free. So $31,000 annually, that's like $40,000 or more with a regular annuity for the remainder of the vet's life. If it's a single vet, $26,000 annually for the rest of their life. Oh, and it goes up every year, cost of living adjustments. So next year it will be more. And here's a pretty awesome thing as well. If there's widow benefits. So a widow of a wartime vet, we're going to check this box by, we actually got a widower in Helena, but typically it's a widow with a husband that served. So let's say that the widow, we check this box with the deceased spouse wartime service, but the widow is 65 or older, suffering from that. I can get them approximately almost a little more than half, $17,000. That's paid monthly. Folks, for a person on a fixed income, this changes lives. This is more than their Social Security. There's one couple in Butte, just tough big guy, just bawling, and the wife was like, "We just don't know what to do with all the money." It's just my favorite thing to do. It's just my favorite thing to do. If I didn't get the opportunity to serve, I had the opportunity, I didn't take it. It's my way of feeling like I'm doing a little bit for our wartime vets, a little bit for me to say thank you for our freedom. But it's also, if you know somebody that might qualify for this, please give us the opportunity to serve them. And you don't have to explain the program, just give them our number. Get them in touch with us. I have yet to have the VA deny one of our applications. Now, we don't submit junk either, but we work with the vet to get them qualified, then we submit. But some of these vets, they don't have a nearby relative, like a child, that can come by and see them and help them out. And in those cases, if it wasn't for this, their only option would be to go into assisted living, leave the home, go into assisted living, then go through their savings or whatever, and then qualify for Medicaid. what I have found is when I can get another $2,600 a month or $2,400 or whatever a month, all of a sudden, now they can't afford full-time care, but they don't need the full-time care. They just need someone to come in and maybe cook once or twice a week, run some errands, do some laundry, maybe help them bathe or whatever. But, you know, like I said, we got one with COPD. We got one guy, he's 68 and pretty dang healthy, but he's got 2 replaced knees. So, you know, you don't have to be an invalid to qualify for this. So, anyway, if I can help somebody you know, or if any of you are vets, allow me to help you. If they're over-resourced, there might be a little waiting period, but let's see what we can do about that. Ladies and gentlemen, you can take your ribbon and move it on your mortar board. You now know more about estate planning and elder law than 90% of the lawyers in Montana. And you're free to go. I'm going to hang out and answer some questions until I lose my voice, which is going to be about 10 minutes. But if you did not get a chance to sign that clipboard, that sign-up sheet, just hang out. We'll get it to you. It's in the back right now. But other than that, you are free to go. Thank you for being a lot of fun and coming out and seeing us tonight. All right.